Good morning, Ms. Hofmer. Good morning, everybody.
Morning, Chair.
Thank you. Are you ready?
We are indeed.
Thank you.
Thank you, Chair. During the course of today, the intention is to receive evidence from two witnesses, Ms. Nhantsi and Mr. Mahlangu. They are both present. They are also legally represented, so I'd like to take a moment, if I may, to allow their legal representatives to place themselves on record.
Thank you. Let them do so.
Thank you, Mr. Commissioner. My name is Sanda Nati Gwina from Gwina Attorneys. I act for Mr. Mahlangu.
Thank you very much, Mr. Greener.
Thank you, Mr. Commissioner. My name is Advocate Nosandi Sosovitu Zwedala. I act on behalf of Phumeza Nhantsi.
Thank you very much.
Thank you very much.
Thank you.
Thank you, Chair.
Yes.
Chair, there are a few procedural aspects just to deal with in advance of the witness being sworn in, if I may.
Yes.
The first of those just relate to the timeframes within which we have received the statements of the witnesses you'll hear from today. Ms. Nyansi's statement was received in enough time to follow the Rule 3.3 processes, and so those have been followed in relation to her statement. Insofar as Mr. Mahlangu is concerned, his statement was received on Friday afternoon. That is just before the long weekend. The consequence of that is that it has not yet been possible to follow a Rule 3.3 process in relation to Mr. Mahlangu, but we have a proposal in that regard, Chair. The first point to note is that almost all of the persons who are implicated at all on the basis of the statement of Mr. Mahlangu have been previously implicated in the evidence of Ms. Stimple and Ms. Nhantsi, so they have received notification in relation to the fact of this evidence and in many respects overlap with the respects in which they are referenced in Mr. Mahlangu's statement. Chair, the second point we wish to make in relation to that procedural aspect is that it would be our proposal in relation to Mr. Mahlangu's evidence that it be received today, and that if in due course it becomes necessary to issue 310 or Regulation 10.6 directives arising from his evidence, that will then be a process that can be followed by the Commission if there are particular aspects of his evidence which require the Commission to know what the version is of other persons in relation to that evidence. What I can state on record, though, is that those persons who have already received 3.3 notices in relation to Ms. Nhantsi and Ms. Stimple's evidence have not applied to cross-examine, bar the two applications that you've already been alerted to, Chair. That is the application from Mr. Zwane to cross-examine Ms. Stimple, as well as Ms. Nhantsi to cross-examine Ms. Stimple. But we've already dealt with the process in relation to that aspect. So, Chair, that is our proposal for the way forward today. But, of course, we seek your direction in that regard.
Well, obviously, from what you have said, there is no problem arising from Ms. Nancy's one. But there are concerns in regard to Mr. Mahlangu. When I read Mr. Mahlangu's statement, well, I didn't have information as to whether the Rule 3.3 notices had been sent out or not, and when they had been sent out, but I had a concern as to whether some of the issues that appear to be in dispute between himself and Ms. Dimple, whether they might not have been resolved if there had been time for Ms. Dimple to look at Mr. Mahlangu's statement and apply her mind to certain issues, because some of them might be based on some misunderstanding, just so that we know what is really seriously contested between the two of them. I had that concern. So One, there is that concern, and two, while there may be, it might be an important factor in terms of what is to be done, that the persons that he may be implicating are persons who have been implicated by other witnesses and they have not applied for leave to cross-examine. We have to always keep our eyes on consistency. Last week, when Mr. Nhantsi was testifying, counsel for Ms. Jiba approached the court and expressed Ms. Jiba's concern that she had not been served with a 3-3 notice, and the result was that I decided that the evidence that would implicate Ms. Jiba and others in matters that were not already in the public domain, in the sense of being in affidavits, in matters that are pending in court or that have already been decided in court or in judgments, should not be covered until at a later stage. Now, in doing so, a very important factor in my mind was the fact that Ms. Jiba had apparently not been notified at all, or not notified in time, even of the fact that there was a witness who was going to be giving evidence and implicating her. And that thinking was in this context, that one, the Rule 3.3 process contemplates that if a person is going to be implicated or is implicated in a statement or in evidence to be given by a witness, that person must be given a Rule 3.3 notice that tells him or her of that fact or possibility, and it gives that person, it also tells that person that he or she may attend the proceedings on the date when that witness gives evidence or have counsel, and that he or she may apply for leave to cross-examine the witness or to lead evidence himself or herself or to call witnesses. Now there is a provision in that Rule 3.3 notice which says if an implicated person or a person who has been served with a Rule 3.3 notice believes that the time that has been afforded him or her before the witness comes before the commission to give evidence is inadequate, then they may apply to the commission for such relief as may be necessary to ensure that they are not seriously prejudiced. Now, the way that things have happened since August has been such that no witness has been cross-examined on the same day that they give evidence. So arrangements have to be made all the time, and persons who need to apply for leave to cross-examine have had ample time, have been given ample time to make that application and so on. But what has happened is that sometimes the Rule 3.3 notices have been served on implicated persons in circumstances where those persons will not get 14 days within which to apply, but where nevertheless they received the Rule 33 notices and therefore they know that they will be implicated by somebody, they know when that person will be giving evidence. One of the factors that has weighed with me is that at least they were aware that somebody is going to give evidence and implicating them. They were aware in advance. They could come and sit and hear and listen. They could brief counsel, instruct an attorney to come and sit and listen. At least they won't have a situation where they may be driving and find that on the news, on radio, they hear somebody is implicating them in something and they had no idea whatsoever. So part of the concern last week with regard to the matter relating to Ms. Jiba was that, as I understood the position, she had not even been alerted that somebody will be giving evidence. Now, coming then to Mr. Mahlangu's situation, it seems that except for one issue, his situation may be in the same position as that of Ms. Jiba. The one issue which might distinguish the two is that, as you say, the persons that Mr. Mahlangu implicates are persons who have been implicated by other witnesses and therefore have been or are aware of allegations against them having been made. So that's that. But I still remain concerned if they are not aware, even by way of a phone call, that somebody will be giving evidence and maybe somebody different may be giving evidence. So I'm concerned about that and the other matter that I raised, namely to what extent we should have a situation where the other persons who have given evidence, or is it one, or it's two, I think, who have given evidence, if they get to see Mr. Mahlangu's statement and maybe somebody in the legal team takes them through to see in regard to which issues maybe there could be common ground. You know, sometimes you say one thing and then somebody brings in a different perspective and you see it from a different angle. You say, okay, now I understand that, and then so that we can remain with only those that are seriously contested. So those are my concerns. I don't know what you might have to say.
Chair, if I may address each of the issues that you've raised. If we can start with the question of the witnesses who have already testified, who may be referenced in Mr. Mahlangu's statement. Chair, it is unfortunate that the statement was only received last Friday. There had been detailed engagements with Mr. Mahlangu in advance of that, and this point in particular was put to Mr. Mahlangu because the disadvantage, if we got it later than the evidence of Ms. Stimple and Mr. van der Merwe, was precisely that we would not be able to put a contrary version to him. So that certainly was made known. Insofar as how to manage it, however, Chair, it is our submission that certainly in relation to Ms. Stimple, I'll check again before Mr. Mahlangu's evidence, but I don't regard anything that he says about the processes in SAA requiring her response.
At least I see she's here, I think.
Indeed, she is, so that she can also indicate to us in due
she's
course.
Attending.
She is attending, indeed.
Yes.
Mr. van der Merwe is different. There is a contrary version in relation to some aspects of what Mr. van der Merwe said, and there are also one or two pieces of correspondence. You'll recall in the course of Mr. van der Merwe's testimony, we asked him if he could go back and check his records for correspondence. He undertook
Yes.
to do so, but we have now found another source of some of that
Yes.
correspondence.
Yes.
It is certainly our suggestion in that regard that after Mr. Mahlangu's evidence, we engage again with Mr. van der Merwe, we put those documents to him, and we ask him for an account. At that stage on affidavit, so we can assess it, and if necessary, there can be a recall of witnesses.
Yes,
But certainly that aspect,
Yeah.
the fact that Mr. Mahlangu's evidence has come in later than those two witnesses, it is our submission that there is a process by
Yes.
which that can be dealt with.
Yes, yes.
Chair, if I may then go to the question of Mr. Mahlangu's evidence today.
Yes, let me just make sure I understand with regard to Mr. van der Merwe.
Yes.
Mr. Mahlangu's statement, you say, does implicate him, or
It-
may implicate him.
It gives a version,
Yeah.
at least in relation to certain interactions
Yes.
between Grisag AG and BNP,
Yes.
which were not able to be put to Mr. van der
Yes.
Merwe.
Yes.
So his account of whether indeed certain not take place,
Yes.
that has not been put to Mr. van der Merwe because that information came to us on Friday.
Yes, yes.
So he would, it's not so much implication
Yes, it's a response.
as response and getting to the truth and the
Yes,
facts about what
yes,
happened at the time.
yes,
We
yes.
would need his account for
Yes.
what Mr. Mahlangu traverses.
Yes. So it's a response to
Indeed.
what Mr. van der Merwe may have said. and-
Indeed, indeed.
Yes.
Mr. Mahlangu received Mr. van der Merwe's statement in advance of
Yes.
him providing his statement.
Yes.
So he was able to respond to
Yes,
it,
yes.
provide further insight and
Yes.
documents which were not previously in the Commission's possession.
yes.
But that came in literally while
Yes.
Mr. van der Merwe was giving the evidence on
Yes,
Friday. So our
yes.
suggestion there is that we will need to ask for Mr. van der Merwe's
Yeah.
response.
Yes.
To the extent that that applies to Ms. Stimple similarly.
Yes.
And then we can make an assessment about whether further oral testimony is required at all.
So what's your submission on whether, in regard to that, Mr. Mahlangu should cover that today or should leave it for later?
He may leave it for later.
Because he would come back, he may have to come back anyway.
Indeed. That is certainly something that we can do
Yes.
in relation to that aspect. We could
Yeah.
carve out, it's a fairly small respect in which he references Mr. van der Merwe.
You have a better idea of how serious an implication it is.
No, it's a point of discrepancy
Yeah,
in relation to certain facts,
yeah,
but in the scheme of Mr. Mahlangu's evidence, they are fairly minor.
yes. Okay, well, in relation to Mr. van der Merwe, one, you say Mr. Mahlangu's statement is a response to
Indeed.
Mr. van der Merwe's statement.
Yes, it is.
Yeah, that's one. Two, you say it's really a minor kind of discrepancy in their versions.
As I read his statement,
As you
Chair.
understand it,
Indeed.
yes. And is it about one issue,
It is
one or two issues?
only one or two, and it's principally about engagements between Grisag
Yes,
and BNP Capital,
yes,
who those engagements were with. You'll recall part of Mr. van der Merwe's evidence was he couldn't recall
yes.
who he was
yes,
speaking to at any
yes,
point in time. What
Yes.
Mr. Mahlangu has provided us with is some correspondence
Yes,
between Mr. Guardi
yes,
and Mr. van der Merwe.
yes,
Mr. Guardi is somebody who will feature in the evidence today, both of Ms. Nhantsi and Mr. Mahlangu.
yes.
So
yes.
it's of that order,
Yes,
Chair.
yes.
And then it's a few details about meetings that were going to be arranged
Yes.
after the date of the 8th of June.
Yes.
Mr. van der Merwe's evidence really stopped on the 8th of June. That's when he attended at SAA and that term sheet was signed.
Yes.
But Mr. Mahlangu's evidence tends to indicate that there may have been later interactions.
Yes.
And so that would need to be probed with Mr. van der Merwe.
Yes.
That is the gist of it.
But the implication might be nothing more than there's a different version,
Indeed.
that Mr. van der Merwe's evidence might not have been true.
Yes, or accurate
Nothing-
in some
or accurate.
respects.
Not-
Indeed.
Nothing
indeed.
more than that.
Not as I read the statement.
Yes, yes.
If Mr. Mahlangu thinks
Yeah.
that there is more in
Yeah.
the implication, he can tell us. But
Yes,
certainly
yes.
as I've read it, those are the issues of
Yes.
discrepancy in versions.
Yes. And, with regard to Ms. Dimple, I think that can be sorted out.
Indeed.
Because she is here.
Yes, it can. The principal issue there, again, as I read the statement, relates to the question of the success fee that was going to be paid to BNP had they successfully sourced the funds. That is an issue that was extensively dealt with by Ms. Stimple because Ms. Nhantsi has a contrary version on that. And so that issue has been debated, but again, Ms. Stimple is here, and if there's need for response, we can certainly pursue that.
Now, with regard to Mr. Mahlangu's evidence in relation to Ms. Dimple, I think I can allow that because obviously Ms. Dimple is aware that Mr. Mahlangu is giving evidence today. She is here. So that concern which I talked about is taken care of. And with regard to Mr. van der Merwe, you say this is a response to his own statement, and that is also a factor. But let's see how we deal with it. May be that on your feet you might just have to exercise your mind about covering it or not covering it until he comes back. But there is something to be said if it's a response. It's just a different version.
It is, indeed.
Yeah. So let's proceed, and you can exercise your discretion as to whether you want to ask if in the process I think we should exclude it. I will let you know.
Indeed,
but
Chair.
The fact that it's a response to Mr. van der Merwe's statement and it's a minor issue, at least as you see it, is an important factor.
I'm indebted to you, Chair, for that direction. I will bear it in mind.
Yeah.
If I can then deal with the question of Mr. Mahlangu's evidence and implicated persons potentially and the approach there. Chair, as I have it, there are really three reasons why Rule 3.3 notices are given. They are given to alert witnesses that they are to be implicated, at least persons, that they are to be implicated in evidence. It's to give them an opportunity to attend and to make application to cross-examine. Those are really, as I see it, the three principal reasons. I'd like to address each of them and submit to you, Chair, that those are not compromised if we were to proceed with Mr. Mahlangu's evidence today. The reason for that is the following. The people who are principally implicated in Mr. Mahlangu's evidence have previously received Rule 3.3 notices. The consequence of that is that their new evidence relating to these matters commenced on Thursday last week through the evidence of Ms. Stimple and then Mr. van der Merwe. In the course of that hearing last week, Chair, there was mention made on a number of occasions that Mr. Mahlangu would be testifying today. That was specifically referenced, I think, in the course of Friday's hearing. So anyone who had been alerted to Ms. Stimple's evidence would be aware and were watching Ms. Stimple's evidence would be aware that Mr. Mahlangu was testifying today. Of course, at the point that that statement was made, it was because Mr. Mahlangu had been summoned. We still were not in receipt of the statement. But that fact has been publicly made known. Chair, the second aspect is, in the world of technological advance, the right to be present in this room is not as critical as it might otherwise be. Chair, as you'll well know, these proceedings are videotaped. They're available online. The transcript goes up the next day. And so the ability to understand the evidence that's given is not as critically needed to be complied with by presence in the room.
Yes.
And Chair, insofar as...
I think once the person is aware that somebody will be giving evidence on a certain date implicating them, I think that's the most critical.
Indeed.
Because even if you might not be able to attend, if you are aware, you might be able to have access to the proceedings in other ways.
Indeed.
But of course, as one says that, one has to bear in mind that there are still lots of people who might not have access
Indeed.
to a lot of things that others have.
Agreed, Chair.
But in all probability, the people we are talking about here don't fall into that category. But we
Certainly.
just have to keep that, at the back of our minds. Yeah.
Chair, if I may make a proposal in that regard, because you referenced particularly the possibility of at least a telephone call to alert persons. Mr. Mahlangu is not due to testify first today. Ms. Nhantsi will, and she will take some portion of the day. In that regard, my suggestion is that we take steps during the course of this morning to notify the persons. There are persons for whom the Commission has contact details because they have been previous recipients of earlier Rule 3.3 notices. And with your leave, I suggest we make those attempts and I can report back to you at an appropriate time as to the success of that notification. But my principal submission is that those recipients of previous 3.3 notices know that this evidence was starting last week, know that Mr. Mahlangu was coming. The only question would be, will they even know that he was coming today? So that they would be aware of that fact as well, Chair. But to the extent that you deem it necessary, we can make endeavours to make that contact in the course of the morning.
No, that's fine. I think for what it's worth, let those endeavors be made. But from what you say, it does appear that it's a matter where we can proceed.
Indeed, Chair.
Yeah.
Thank
But I'm
you,
not
Chair.
cutting you short.
Indeed.
Yeah.
No, certainly,
Okay.
Chair. Thank you. Chair, then just in relation to one or two other procedural matters, there are a few documents that have been handed up this morning to me by Ms. Nhantsi in relation to her testimony and one additional document in relation to Mr. Mahlangu's. I beg leave at the appropriate point to hand those up to you, Chair. There is also a question in relation to documents that Mr. Mahlangu received over the weekend from the Commission, which were relevant after we had received the statement. There's an aspect there, I've dealt with his legal representative and him about that this morning, and I will place that on record, but I propose to do that just in advance of Mr. Mahlangu's evidence and not at the outset now, if that is convenient, Chair.
No, that's fine. There is a person that Mr. Mahlangu mentions frequently in his statement that appears to have played quite an important role in his company in regard to BNP and SAA.
Indeed, Chair.
Do you know whether that one is aware that Mr. Mahlangu will be giving evidence? They were working on the same site.
Indeed.
During those
Chair, he received notice of Ms. Nyansi's evidence,
Yes.
has received the full statement and annexures of Ms.
Yes.
Nyansi's evidence.
Yes.
He features prominently in her evidence.
Yes.
He would also, had he been, he was also implicated in Ms. Stimple's evidence.
Yes.
And so, no, I stand corrected there. He was not implicated in Ms. Stimple's evidence, but he did receive notification of Ms. Nyansi's evidence.
Yes.
And so to the extent that he was taking note of the proceedings last week, he would have been alerted to Mr. Mahlangu's appearance.
Yes.
But insofar as those calls will be made, my
Yes.
suggestion is that we start with them
Yes.
this morning.
Yes. Of course, Mr. Mahlangu's statement suggests that he was the one who wrote letters and
Indeed.
played a certain role.
Indeed.
There may be room for an interpretation that Mr. Mahlangu is not necessarily saying he was involved in anything wrong, but is saying to the extent that he may have been involved in anything wrong. Mr. Mahlangu was unaware of it. So I think maybe he must be one of those who must be notified.
Indeed.
Yeah.
Chair, we'll take those steps and I'll report back in
Yeah.
due course.
Okay, thank you.
Thank you.
Okay.
If I may just take a moment.
Yeah.
Thank you, Chair. Chair, if I may then ask for Ms. Nhantsi to be sworn in.
Yes. Please administer the oath or affirmation.
Please state your full name for the record.
Phumeza, Nhantsi.
Do you have any objections to taking the prescribed oath?
I don't have any objections.
Do you consider the oath to be binding on your conscience?
Yes.
Do you solemnly swear that all the evidence that you will give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you.
Thank you. You may proceed.
Thank you, Chair. Ms. Nhantsi, just in relation to some housekeeping matters, you have before you a file which contains your statement, annexures and additional documents which you've previously been provided with. Chair, for the purposes of the record, may I request that this be marked Exhibit DD2 as is referenced on the spine of the file?
The liver arch file containing Ms. Nyantsi's statement will be marked Exhibit DD2.
Chair, there will also be cause in the course of Ms. Nyantsi's evidence to refer to one or two aspects of the statement of Mr. Mahlangu. And so for records purposes, if we could just enter that in as Exhibit DD4, as is referenced on the spine.
The liver arch file containing Mr. Polisani Daniel Mahlangu is to be marked Exhibit DD4.
Thank you, Chair. And Ms. Nhantsi, just to orientate you, you have a box of files next to you. Those contain the bundles of witness statements and evidence other than your own. At appropriate points, I'll ask you to take them out, and I may refer you to aspects of them. Just to orientate you, Ms. Stimple's statement is represented over 3 files. They're called DD1, A, B, and C, so I'll make that reference to you to know which file to look at any point. And then you've just been alerted to the fact that Mr. Mahlangu's exhibit will be DD4. If you have any concerns, let us know in the course of the evidence. Ms. Nhantsi, if we could then go to your statement, which is in Exhibit DD2. And if you turn to page 1 of that statement, at least that bundle, that is the first page of the statement as I have it. And then if you turn up page 23, that is the last page as I have it. Can you confirm that that is your signature appearing on that page?
Yes, Chair, I can confirm that it is my signature.
Ms. Nhantsi, I know that you want to make one correction in relation to your statement, which I'll allow you an opportunity now to do. I then will ask you, after that correction is made, whether you confirm the correctness of the facts as they are set out in the statement.
Yes.
So if we could begin with the correction.
Yes, Chair. Thank you, Chair. The correction which I will apologize is the spelling of Ms. Stimbel. It's supposed to be M-P-E-L instead of Stimble. I apologize for that. I do have a second correction, Chair, but I'm trying to orientate myself with your version of the statement, especially with the pagination. Just give me 1 sec. There's a correction that I want to make.
Certainly.
Thank you, Chair. On my statement is PN 014. It's on paragraph 49, Chair. The sentence start with, I had discussed my concerns and the cancellation fee with other.
I'm sorry, did you say paragraph 49?
Paragraph 49, Chair, yes.
That's not on my page 4.
14,
page
Chair,
14.
14.
1
Sorry,
4.
14, yes.
Oh, okay.
Apologies, Chair.
Thank you. Yes.
Yes. The sentence start with, I had discussed my concerns about the cancellation fee with other 2 board members, Ms. Yake Kwinana and Dr. Tambi. In return, they voted against the cancellation. I would like to make a correction there. They abstained. They didn't vote against. Thank you, Chair. Those are the corrections that I wanted to make.
Thank you, Ms. Nhantsi. One other point I should just make clear. The paragraph numbers on your statement were in fact, other than paragraph 1 and 2, were added by the Commission after receipt of your statement because we had to have a way to navigate within it, particularly for the purpose of Rule 3.3 notices. I take it you don't take issue with that.
No, I do not.
Thank you.
Well, I see that at the end of your statement at page 23, after signing, you said yours faithfully.
Chair,
Yes.
because I'm not legally acute, I'm not, was I supposed to say yours sincerely?
No, not really. It's just that it's a statement and not a letter. So
No.
I was wondering.
Apologies, Chair, I'm an accountant.
You're an accountant,
Yes,
yeah.
yes.
Yeah. Okay. No. I mean, there is no issue. It just caught my eye.
Okay.
Okay.
Thank you, Chair. Ms. Nhantsi, I'd like to just begin with, for record purposes, noting that you have made an application to cross-examine Ms. Stimple. That will be dealt with in due course by the Chair. Did you have an opportunity to watch or otherwise follow the evidence of Ms. Stimple and Mr. van der Merwe last week?
Yes, through you, Chair, yes, I did have an opportunity to watch both Ms. Stimble and Mr. van der Merwe.
Thank you. That's just helpful for me to know because I can make reference then to some of the aspects of what was covered in that testimony. I'd like to begin, Ms. Nhantsi, with really your start at SAA. And for that purpose, if we could turn to page 2 of your statement and pick it up at the start of that page. It's the second part of paragraph 4, which begins on the previous page, because there I have it that you commenced at SAA on the 27th of November 2015. Is that correct?
Yes, it's correct, Chair.
Can you tell us about how you came to be appointed at SAA on that date?
Yes, Chair. I am Phumeza Nhantsi, a qualified chartered accountant. I was working at Sizwe Nsaluba Gobodo, it's the accounting firm. I had an audit that I was doing, the joint audit. In fact, it was subcontracting with Kwinana and associate, Daniel. So Sizwe Nsaluba Gobodo was the main auditors. That's how I knew Ms. Kwinana. One of the days she asked me that if I would be interested in the aviation because I do have an experience in aviation as I was auditing Daniel. I said it would be a nice experience to explore the corporate world, but she told me that they need to follow the process as the board because my predecessor, Mr. Wolf, left the company. They're looking for a secondment at the time. She then engaged with the CEO of SNG. His name is Victor Segese. One of the days later in the year, I think early of November, I was called by Mr. Segese, my CEO, to ask if I would be interested. There's an opportunity for a secondment. I said yes. Whilst I was happy with working at SNG, I was curious in wanting to explore the corporate world. So I said yes. My understanding, and based on the bundle that I saw, there were 3 CVs that were sent to SAA, and my CV was selected. And I was then called by CEO Victor Mr. Segese to come and sign the secondment agreement, which made me to then start at SAA on the 27th of November 2015.
And you occupied an interim CFO position, is that correct?
At the time, yes, I was the interim CFO, but I was a secondee because I was still paid by SNG. There was an agreement between SNG and SAA on the payment arrangements.
And when did your status change from interim CFO?
My status changed effective 1st of May 2017. There was a recruitment process that was done by the company and the board at the time. If my memory serves me right, the headhunter agents that they used was Mindco. I applied like any other candidate, and I then qualified. I was told that I'm the one who was suitable and who won the position. So I then became permanent CFO effective 1 May 2017.
So would it be correct that until that point you were in the secondment position and your title was interim CFO?
Yes, Chair, I would.
Thank you. Ms. Nhantsi, you referenced the fact that you are a qualified chartered accountant. That is also apparent from your statement on page 2. Ms. Nhantsi, I take it then that you would have a good understanding of the fiduciary duties of directors to companies on which they serve. Is that correct?
Yes, it's correct, Chair.
What do you understand those fiduciary duties to comprise?
I don't know them off by head, Chair, but one of them is I'm responsible for the company to safeguard the assets of the company and to act in the best interest of the company. The others I would have to refer, Chair.
Indeed. For present purposes, the ones I'd like to focus on are acting in the best interest of the company. So can I understand it that you would have understood at the time and do now that that's a key requirement of a director?
Yes, Chair.
The other one taken from section 76(3) of the Companies Act is to act in good faith and for a proper purpose. Would you accept that those are duties and you would have been aware of those at the time that you took up the CFO position?
Yes, I was aware, Chair.
Thank you. Ms. Nhantsi, your statement also indicates that you understood the processes of procurement by state-owned enterprises. Is that correct? Is that a fair statement for me to make?
It is. I fairly understood them.
And was it part of your understanding that the general position for state-owned companies when they procure services is that they must do so pursuant to an open and competitive tender process?
Yes, Chair, when it's practicable to do so, yes.
Indeed. And so I take it to also have been part of your understanding that there might be exceptional circumstances where that isn't possible. Is that right?
Yes, yes, Chair.
But those would have to be justified, correct?
Yes.
And they would have to be justified within the system that has developed within that company for departures from the default position, correct?
Fully agree, Chair.
Thank you. I'd then like to move, Ms. Nhantsi, to Mr. Massad Guardi, because he is a person who features prominently in your statement, and I'd like to just get some understanding of your interactions with him, when they commenced, how you came to interact with him. If we can start with when they commenced. You indicate in your statement, and we can go to page 12 for this, at paragraph 40,
Yes, Chair.
you say in the course of that paragraph, right at the bottom of the page, you say there, immediately when I joined SAA, the chairperson of the board gave me Mr. Mngadi's numbers and told me that he is an advisor. And also, if I have any questions in the submissions that I was busy with for the swap deal, I should contact him. He was also given my number by the chairperson of the board because he contacted me. So can we take it that that occurs shortly after 27 November 2015?
Yes, Chair, I can confirm. If I'm not mistaken, I'm sure it happened 2 days after I've joined. The chair of the board, Ms. Mieni, gave me the number of Mr. Mngadi. At the time that I joined SAA, the board and executives were busy with the correspondence between the minister at the time about the swap deal. So I didn't even have a clue of the swap deal, but there was a letter that was needed to be prepared as a response to the Minister of Finance. So in preparation for that, together with the acting CEO, Ms. Mieni gave me the numbers of Mr. Mngadi, saying Mr. Mngadi is his advisor. He is fully aware of the transaction. If I have any questions or after I've drafted the letter, I can touch base with him. He knows the transaction. So before I could contact him, he contacted me. Hence I'm saying Ms. Mieni gave him my number.
Indeed. And can I take it that you saved those details into your phone at the time, shortly after you arrived at SAA?
Yes, I saved them, Chair.
And did Mr. Mngadi contact you on your cell phone as opposed to the work landline?
He contacted me on my cell phone, Chair.
Oh, so that's why you say it would have been Ms. Mieni who would have given him your cell number?
Yes, Chair.
Okay.
And that would be the phone that you saved his details into, is that correct?
Yes, Chair.
Thank
So
you.
that is perhaps to conclude, that's the first time that I started engaging with him. I didn't know him before.
And you referenced that he was an advisor. Had he been appointed through a procurement process into that role?
I didn't ask that question to Ms. Mieni at the time. I took it, the process was done before my time.
Did you ever make inquiries about that?
I made inquiries through you, Chair, and I then realized or concluded that he is, Mr. Mngadi is his personal advisor, because when I made inquiries to Miss Kwinana, she told me that it's Miss Mieni's person. And because I was making inquiries, because there was also another person who was the advisor, who was Mr. Nick Linnell. And I understood that he was appointed through a process. So I was curious to understand how Mr. Mngadi was then appointed. So Ms. Kwinana told me that it's Ms. Mieni's person.
Can I just clarify, does that suggest that there wasn't then a formal process to appoint Mr. Mngadi, that he was there simply as an advisor that Ms. Mieni utilized?
That was my understanding.
And whenabouts did you make that inquiry?
Beginning of January.
Of 2016?
Sorry. I started 27 November. I made that mid of December.
Right.
You say that you were told that Mr. Mngadi is his personal advisor. You mean Ms. Mieni's personal advisor?
That's
is that what you were told?
Yes, Chair. That's what
Yes.
Ms. Kwinana told me.
Okay, so as distinct from being an advisor to the company?
To the board.
To the board.
Yes, Chair.
Okay. Would you know whether what you were being told was that Mr. Mngadi was Ms. Mieni's advisor in her capacity as chairperson of the board, as opposed maybe to being advisor to the board, or that he was Ms. Mieni's personal advisor in whatever matters that the two of them decided he would advise her?
Chair,
Or is there something you didn't understand?
how I understood it is because with the engagements that I had with Mr. Mngadi, he knew a lot about SAA. But I wouldn't say he was, perhaps he was his personal advisor, because he was not paid via a payroll of SAA.
Oh,
So hence I'm saying, I
Yes.
think Mr. Mngadi was
was her personal
was her
advisor.
personal, yes, Chair.
Okay, all right. And that he was not paid through SAA, that is Mr. Mngadi, is something you would know, of course, because you were the interim CFO.
Yes, Chair.
Yeah, okay.
As I understood your evidence a moment ago, Ms. Nhantsi, you were told by Ms. Mieni to engage him immediately after you arrived at SAA because there was a letter that needed to be prepared in response to National Treasury on the swap deal. Is that correct?
Yes, Chair.
Did he assist you in crafting that letter?
Yes, he did. He gave me the input to include in the letter. And then when I finalized the letter together with the acting CEO, we then sent it to the board. They reviewed it, and the letter went to National Treasury.
Did that not strike you as strange at the time that some third party to SAA, who wasn't being remunerated by SAA at all, was going to be advising you on what letters to write and their contents back to National Treasury?
It did raise a bell, but Ms. Mieni said Mr. Mngadi is my person for any issue that I need to get clarity on. If Mr. Zwane is not aware of any, Mr. Mngadi knows very well about SAA. He's been working with him.
But he's not an employee of SAA?
No, to be honest, I never asked Ms. Mieni how is Mr. Mngadi paid.
But you later established that, apologies, Chair.
I think we have the same question in mind. Proceed.
But you established later he was not paid by SAA?
Yes.
Thank you.
That is quite, sorry, that's quite strange. That, I asked you earlier on whether you understood that when it was said that Mr. Mngadi was Ms. Mieni's personal advisor, whether what was meant was that he was Ms. Mieni's advisor in her capacity as a member or chairperson of the board, and you said no, you understood that he was just her own personal advisor, and in support of that you said he was not being paid by the board, and it's quite a strange situation, and I said, I mean, you obviously checked as interim CFO, you would know if who is paid, who is not paid by the SAA. So somebody who is an advisor to somebody who happens to be chairperson of the board or a member of the board, but is a personal advisor, is asked to advise you.
Chair, perhaps I should have attempted to answer in two ways.
Yes.
By saying, one, he was not paid via SAA payroll, and two, he was advising Ms. Mieni. I'm not sure about other things, but he was advising Ms. Mieni on SAA matters, because Ms. Mieni said, if there's any queries or any questions that I have, Mr. Mngadi had got a deep understanding of SAA.
Yeah, no. I understand the qualification that you are making, and it's a legitimate qualification. But what does remain is, why would she, and this is something you might not have an answer for, why would she want somebody to do work that assists the interim CFO of SAA, or that assists SAA, but SAA doesn't pay that person? That's strange, because if SAA needs advisors must be secured or procured in a certain manner, and they get paid by SAA.
Yes, Chair. Hence, I inquired with Ms. Quinana, and Ms. Quinana said to me, Mr. Mngadi she put it roughly to say, Mr. Mngadi is Dudu's person.
What, Mtuga?
Mtuga Dudu.
Mtuga Dudu. Well, I just used isiZulu because I could understand exactly when she was speaking in English what must have been said
Said
in
in Zulu.
isiZulu, and she has confirmed. So,
Thank you, Chair.
okay, thank you.
Ms. Nhantsi, I'd like to just probe a little bit further pursuant to the debate, the discussion that you've been having with the Chair. It sounds to me from your description as though there was a third member of the executive management team of SAA. Because as I had your evidence earlier, you were told if there were matters in relation to SAA affairs that Mr. Zwane, who was the acting CEO at the time, would not assist on, then you were told to go to Mr. Guardi, which puts him as one of the three people who were in the executive position at SAA. Is that a fair summary of how you interacted with him?
Not really, but you are right, and I don't want to say you are right and wrong, but halfway there. The only issues that I would get clarity perhaps from Mr. Mngadi would be the ones relating to the board. So I wouldn't say he was the third executive, because on other matters relating to the day-to-day running of the business, I was not engaging Mr. Mngadi.
So when SAA was writing letters to National Treasury, in what capacity were you preparing those letters?
I was preparing the letters. In terms of the protocol, those letters they need to be signed by the chairperson of the board and go to National Treasury. So he was then assisting in giving input, and myself and Mr. Zwane would write the letters, give the letters to the board, for the board to review, and for the chairperson of the board to sign the letter and send to National Treasury.
The board and the chair would rely on their executive team for the
Yes.
input into those
Yes.
letters. Is that
Yes.
correct?
Yes,
That's in accordance with proper corporate governance.
yes, Chair.
Do you agree that it's strange that a third party who's not a member of the executive of SAA is making input into that which the executive team places before the board?
Yes, it is strange, Chair, and also we need to be mindful, or perhaps I need to highlight that those days I was a week or 2 weeks old at SAA, so I was not really accustomed to how SAA worked.
Indeed. Thank you, Ms. Nhantsi. We'll come back to the question of at what point in time you may have become more concerned about the role of Mr. Mngadi. I'd like to, though, you mentioned the swap transaction. For those uninitiated in relation to the swap transaction, could you please assist us with what that related to?
Chair, I came at a very late stage on the swap deal transaction. I don't have much memory on it because I was not involved from the beginning of the transaction, but my recollection, I came at the time when there were letters between the minister and the board. I recall a letter where it was saying the minister of finance was giving an instruction to the board to stop the swap deal. My understanding was many years ago, SAA ordered aircrafts that were wide body aircrafts. My understanding there were 10 or 20 then. Now they wanted to swap those aircraft. So the debate or the discussions were along those lines. So I came at a stage where there were those letters where then an instruction from the finance minister saying stop the transaction and all that. So that's the background that I have.
Thank you, Ms. Nhantsi. Chair, this is an aspect that will come up in all likelihood in the second evidence session for aviation. But just for the assistance of understanding Mr. Mngadi's role, he was particularly involved on that Airbus swap transaction. Is that correct?
Yes, Chair, he was involved because he knew he was the one who was giving me the background, myself and Mr. Zwane, background on that swap deal.
Thank you. Could I ask you to go to page 200 in the bundle in front of you? That's DD2. It contains your statement, and it's an additional document.
What page again?
200, Chair.
Thank you.
Yes, I'm there, Chair.
If you just go, apologies, Chair.
Thank you.
If you turn to the last page of that letter, it appears at page 202, can you tell us who signs that letter?
Yes, Chair. It's signed by Massad Guardi, Executive Client Coverage.
Is that the same Mr. Guardi we've been speaking about?
Yes, Chair.
This is a letter that relates to the Airbus swap transaction. Is this a letter that you were aware of at the time?
No, Chair. I was not aware of the letter.
Thank you.
The letter, Chair, perhaps to substantiate, is dated 30th October 2015.
Indeed. What I was interested in was whether in your engagements with Mr. Guardi after your arrival, which is of course later than this date, whether this letter was ever presented to you or you considered it. You'll see that it deals with the role for the assistance of the South African Airways in its procurement of new aircraft. And it sets out a great deal of detail about what the advantages would be for SAA if it were to conclude a lease transaction in relation to these aircraft. So when you were working on this matter and engaging with Mr. Guardi, was this letter brought to your attention at all?
No, Chair, it was not. And my understanding, I think this letter is still perhaps substantiating or motivating the advantages. So I came at the time when the minister was saying stop the swap deal.
Thank you. Insofar as your engagements with Mr. Guardi in relation to BNP is concerned, when did those occur?
Yes, Chair, I'm trying to go back because this is 4 years ago and I would like to be as
Yes.
accurate as I can.
Yeah.
There were engagement, as I said, I started engaging Mr. Guardi in 2015. BNP came in the picture after the transactional advisor. I think at the time, I was also engaging with him on the BNP transaction.
Well, let me maybe just assist with the chronology.
Okay.
BNP, the bid for the transaction advisor services was in the middle of March 2016. My question would be, do you recall whether you engaged with Mr. Guardi in advance of that or only after that in relation to that transaction advisor service?
Are you saying in terms of the bid to appoint the transactional advisor?
Yes.
No, the bid was done. I didn't engage Mr. Guardi on that. The bid was done by the bid adjudication, the bid evaluation, and the bid selection committees, which I don't sit in any. So the only time that the recommendation came to me was after all those committees have concluded the work that needed to be done, and BNP was motivated as a preferred bidder for a transactional advisor.
And then engagements with Mr. Guardi about those transaction advisor services, did that occur only after their appointment?
Yes, it did. I would also like to highlight and say, according to my recollection, because the reason why I'm saying so is there was interaction in a way. Sometimes regarding BNP, there will be Mr. Mahlangu writing to me, and there will be Mr. Guardi calling me. So if you ask me, I see Mr. Guardi also as a team player in the BNP Capital Company.
Thank you. There is a reference to a meeting that was held with SAA in Mr. Mahlangu's statement. I can take you there in a moment, but let me just tell you what it is. There were meetings held on the 25th of April and the 26th of April, which Mr. Mahlangu said Mr. Guardi attended on behalf of BNP. Would you be able to confirm whether you were present at those meetings?
25th and 26th.
Of April, yes.
Chair, I would like to go there. The reason for that is there was a meeting that I attended
Indeed.
and Mr. Mngadi was there, but it was with Mr. van der Merwe.
That would have been on the 8th of June. So what I'm interested
even
in
before
was, prior to that, let me take you to Mr. Mahlangu's statement so we
Alright.
can place it in context. That is Exhibit DD4.
Yes. Yes.
You'll find it at page 18 in that statement.
Yes.
So at paragraph 5.18 on page 18, the following is recorded. During the process of doing a financial analysis of SAA's balance sheet and meetings Mr. Mngadi held with SAA on the 25th and the 26th of April 2016, we became aware of the fact that SAA could no longer wait for the financial advisory services to be completed, as SAA was in dire need of funding because of, amongst other things, and then 3 reasons for that position of urgency are traversed. If you go over the page, though, to paragraph 5.19, it records, as a result of the above findings, Mr. Mngadi advised that the consortium, that is a reference to the consortium between BNP Capital and Inline Trading, had been asked to submit a proposal in this regard. Ms. Nhantsi, if we just step back, what I understand these 2 paragraphs to be saying is there was a meeting at SAA on the 25th and the 26th of April, which Mr. Mngadi attended, and at which the dire situation of SAA was discussed, and at which he was asked to submit a proposal for the sourcing of funds. Do you recall having been at those meetings on those 2 days?
No, Chair, I was not in these meetings.
Who would he then have been meeting with?
The content on these, the maturity dates and the amounts of the loans that were maturing, I'm aware of, but I never had a meeting at SAA with Mr. Mngadi and discuss this.
Would those not have been the obvious things that you were responsible for in your
Yes.
portfolio?
Yes, hence I'm saying I'm familiar with the content.
So would it strike you as odd that there would be a meeting arranged between SAA and Mr. Mngadi to discuss matters directly in your portfolio that you did not attend?
Yes, I would say it's odd, Chair.
And are you quite sure of the fact that you weren't at those 2 meetings?
I'm 100% sure, Chair.
Thank you.
Would there have been anyone under you who may have attended without your knowledge?
Chair, I'm not aware. I never got any feedback
Yes,
of the meeting that happened for 2 days,
yes,
discussing these points.
yes.
Yes.
And are in a position to say it's unlikely that somebody under you would have attended a meeting of that nature without mentioning it to you in one way or another, without you becoming aware.
Yes, Chair, I'm certain that if they attended a meeting, especially a meeting that takes 2 days, I would have been aware that they are attending a 2-day meeting, and I would have been briefed when they are back from the meeting.
Unless maybe if they didn't want you to know that they attended.
Maybe, Chair, that's a possibility, but yeah.
Okay.
Ms. Nhantsi, I'd like to then ask you to go back in your file, which is Exhibit DD2, to page 285.
I'm there, sorry, Chair.
Is that back to the
Back
To
to
the exhibit.
DD2, and it's at page 285.
285? Thank you.
Yes, I'm there, Chair.
Ms. Nhantsi, can you help us with the email at the top of that page? Can you tell us who it's from and who it's to?
It's from Guardi to Phumeza, to myself.
Thank you. And the content, would you just read that into the record, please?
Good afternoon, madam. Please find attached under cover here of a letter for your kind attention. Looking forward to engaging with you on this issue. Thanks, kindest regard, Guardi.
And then if you turn over 2 pages just to get the attached letter, you'll see that that is a letter from BNP Capital dated the 29th of April 2016.
Yes.
Can you tell us who that is from?
It is from Daniel Mahlangu, the CEO of BNP Capital.
And it's addressed to who?
It's addressed to the Chief Financial Officer of SAA.
Is that yourself at the time?
Should have been the interim, yes.
And if you'll just read the first sentence there.
Further to our meetings of 25 and 26 April regarding SAA's financial state of affairs and our interrogation of the SAA financial information, including its balance sheet and income statement, it is our considered view that a transactional advisor mandate has been augmented for the following reasons.
Thank you. There's no need to go on for now.
It has to be augmented.
Indeed.
Yeah.
Ms. Nhantsi, do you recall receiving this email?
Yes, I do, even though it was a long time ago. Yes, I do, Chair.
And do you recall that attached letter?
Yes, but I still don't recall the meeting, the 2-day meeting that I had.
Did you then go back to him and say, I don't know what meetings you're referring to?
No, I don't recall going back, Chair. But all I can say that I know that I did was to send the information, the debt profile of the company, because already at this time they were appointed, BNP Capital was already appointed as a transactional advisor. So the information of the debt profile of the company was given to them. But a 2-day meeting, I don't recall.
But this is a letter related to expanding the scope of the transactional advisor services, isn't it?
It looks like, Chair.
Yes. And it seems
I'm sorry,
to...
Ms. Hofmeyer.
Sorry, Chair.
Has she had a chance to read the whole letter?
Apologies. Let's give her that opportunity.
Have you had a chance to read the whole letter?
It was a long time ago, Chair, if I can be given a chance.
No, I mean recently, to refresh your
No.
memory.
No, Chair.
Okay. It might be necessary that if you feel that you need to get the context, just indicate. I wonder, Ms. Hofmeyer, whether there aren't particular letters or documents that you might want her to have a little bit of time to look at properly.
Indeed.
Because it's been a long time, and she might just refresh her memory.
Chair, we have no difficulty with that.
Yeah.
Just in terms of the procedure, all of these documents were sent to Ms. Nhantsi about,
they were sent?
Indeed, about a week or so ago.
Oh,
So
okay.
she has been in
She had
receipt
the
of them for
chance.
that
Oh,
period.
okay.
It
That's-
was on the basis of that engagement that
No,
I had
no.
assumed we could work with it. But Ms. Nhantsi, at any point that you'd like to go over a document to refresh your memory, of course,
Yes.
you should
okay,
indicate
no, that's
that.
right. No, I thought she might not have had that
Indeed.
chance. So it's fine if she has had that chance, but if in order to respond, you just want to have a look again at any document, just let us know.
Yes, Chair, if I can be given 2 minutes just to read this one specifically. I'm done, Chair. Thank you.
Okay, just before we proceed, you did receive these documents about a week ago or so?
Yes, Chair.
Yes. Did you get a chance to read them?
Yes, Chair.
Yeah. Okay, I'm just wanting to alert you that I've allowed you with this one, but
Okay.
I won't allow you to go through everyone in circumstances where you did have a chance.
Okay, Chair.
When I say I won't allow you to go through everyone, that is to read from beginning to end, but obviously, if you want to just have a look at a particular part, that's fine.
Thank you, Chair.
I was getting the impression earlier on that you might not have had a chance to look at the letter recently. So,
Thank you, Chair, for your indulgence.
so the idea is to try and be fair to you, but at the same time, we want to use our time properly.
Okay, Chair.
Okay.
Thank you.
Thank you.
Thank you, Chair. Ms. Nhantsi, can I just confirm, your evidence indicates that you did not attend a meeting on the 25th and 26th of April with Mr. Guardi, is that correct?
Yes, Chair.
Did you attend a meeting on those days with Mr. Mahlangu?
No, I never attended a meeting with Mr. Mahlangu. I've never seen him.
Right.
I've been sending information to him.
Thank you for that. In relation to this letter, though, I would like to probe it a bit further because it comes to you on the 29th of April and it refers to meetings on the 25th and the 26th of April regarding SAA's financial state of affairs.
Yes.
That's your portfolio, is it not?
Yes, Chair.
Were you not surprised to learn of meetings happening within your portfolio 3 days and 4 days prior to receiving this letter, which you did not attend?
Chair, chances are I would have been surprised, but this letter dated 29th of April 2016 comes at a time where allow me to go back, we received an update or news from FDC that we will no longer be getting funding to the tune of 15 billion because of the directive that they received from National Treasury that they should stop giving SAA funding. So we had then a meeting with a telecon with the board, updating them about this. So the board then asked us on the 21st of April that we need to explore expanding the scope of BNP to include the sourcing of funds. So now this is 29th of April, this is after that date. So this is the date where we already received a resolution from the board to expand the scope of BNP to include the sourcing of funds. So the content that are on the letter is what we discussed also with the board in raising concerns on the agency of the loans that are maturing at the end of June to the tune of 7.3 billion. Some of the content of the letter talks about what was on the scope of the transactional advisory services.
Indeed, Ms. Nhantsi, that board resolution of the 21st of April, you will find in Ms. Stimple's bundle, bundle B, at page 441. It's not particularly necessary that you go there. I just want you to be assured that there was a board resolution by round robin on the 21st of April resolving to approve the extension of scope of a transaction advisor to include sourcing of funding of 15 billion for South African Airways. Is that the one you're referring to?
Yes, Chair.
My question still remains, though, Ms. Nhantsi, how could it be that Mr. Mahlangu or Mr. Guardi and BNP Capital were having meetings pursuant to that board directive on the 25th and 26th of April, at which the financial state of affairs of SAA were being discussed, and you as the CFO of SAA had no knowledge that those meetings were taking place?
I don't know, Chair.
And you have no insight for us as to who they would have been meeting with if it wasn't you or your department?
Now I would have to speculate. I don't know, Chair.
Thank you.
So did you respond to this letter which suggested that you were part of meetings of 25 and 26 April 2016. Did you respond to it?
No,
and point out that you don't know what they were talking about?
No, Chair, I did not respond. Hence, I'm saying the letter dated 29 came at a time where we were busy then trying to do the procurement process based on and check the confinements based on the fact that there are loans that are urgently coming to mature. So chances I would have received the letter, maybe I wouldn't have even given the attention on the detail of the letter because we were urgently trying to get the confinement, working with procurement to confine and source the funds because the loans were about to mature.
Well, do you know whether you read the letter at that time after receiving it?
I don't recall it, Chair.
Do you know whether you did receive the letter at that time?
It was on my mailbox, Chair, so yes, I received the letter.
So you did receive it?
Yes.
But
reading it, I don't recall
you
it.
don't know
Chair.
whether you read it
Yes,
at all?
Yes.
But of course,
But Chair, let me also continue. As I'm saying, some of the content of the letter is what is the mandate of the transactional advisor, which BNP Capital was appointed to do.
no, I understand what you're saying. I'm concerned that you don't remember whether you read the letter. Am I correct in understanding your evidence in that way, that you don't remember whether you read it or not?
No, I don't remember, Chair.
Yes. Because I would have expected that when you read it now, you would remember if it's a letter that you had read before. But you do remember that you did receive it, that you have no problem with.
Yes, Chair.
Yes. Is it possible that you would have ignored it and not read it?
Chair, it's possible that I might not have deliberately ignored it,
Yeah.
but because we're too busy, I would have perhaps forgot to read it at the time.
Yes, Ms. Phumeza.
Ms. Nhantsi, I'll come back to that point in due course, if I may, when we deal with your motivation for the extension of the scope, because certainly some of the motivation that is contained in this letter is what ultimately finds its way into your motivation, which I'll suggest to you in due course is at least an indicator that you were familiar with the contents of the letter. But I'm happy to go to that in due course. Before we leave the topic of interactions with Mr. Guardi, I'd like to just take you to some of the WhatsApp communications that you've provided to the Commission of your interactions between yourself and Mr. Guardi. And for that purpose, if we can maybe just go to, in that same bundle, page 101.
I am there, Chair.
What is that, Ms. Nhantsi?
It's a WhatsApp message, sorry, Chair, from Massad Guardi.
And is this from the phone that you saved his details into, as you described earlier in your testimony?
Yes, Chair.
And as he's reflected at the top there, is that how you saved his details?
Yes, Chair.
Massad Guardi, SAA Nedbank.
Yes, Chair.
So in late November, 2 days after you arrived and you got his details, you were aware that Mr. Guardi was associated with Nedbank. Is that correct?
Yes, Chair. He told me.
He told you?
Yes.
Thank you. Can I then ask you to go next? Well, what I'd like to do, Ms. Nhantsi, is just for the purposes of navigating your evidence, indicate that there are 5 decisions that were taken in relation to the BNP, at least the 15 billion capital raising, which are of particular importance as we try to unravel what happened in relation to this fundraising at SAA. I'd like to take you initially through those 5 decisions and have your evidence in relation to whether you today stand by those decisions that were taken. And I do so, Ms. Nhantsi, because, and you'll correct me if this is not a fair reading of your statement, but as I read your statement, you may well have supported decisions at the time, knowing what you knew, but you raise serious concerns about them now. Is that a fair reading of your statement?
Yes, Chair.
So for introductory purposes, I'd like to just go through the 5. I'd like to get on record what your position is in relation to those 5 in broad terms. And then my proposal for the rest of your evidence is to delve into some of them in a bit more detail, where it becomes relevant to do so.
Okay.
If we can start with the decision to appoint the Free State Development Corporation to source the 15 billion. Ms. Nhantsi, you'll recall that that occurred in a December 2015 meeting of the board. Is that correct?
Yes, Chair.
We've looked at that resolution in some detail in Ms. Stimple's evidence, but I'd like to have you to have it before you for this purpose. You'll find it in A of her exhibit, which is DD1. And you'll find it at page 289 of that bundle.
Yes, I'm there, Chair.
Is that an excerpt of the minutes of the meeting held on 3 December 2015 of which you're familiar?
Yes, Chair, I'm familiar.
And you'll see in C on that page is where the decision in relation to the Free State Development Corporation is contained. And what I read it as mandating you and the acting CEO to do is to urgently take the necessary steps to negotiate, conclude, execute, and sign and or dispatch all documents and notices related to the 14 billion loan offer received from a potential funder, Free State Development Corporation, as per the letter circulated at the board meeting. You see that?
Yes, Chair.
Do you stand by the decision that was taken by the board on that day to mandate you to conclude that transaction with Free State Development Corporation?
Please guide me. You want me to perhaps first substantiate why I stand by it then, and why now I've changed my mind perhaps.
I'm interested in your current position.
Okay.
And we'll go into great detail in the course of your evidence about what was happening at the time, what you were aware of, but your current view. What I'm interested in the moment, because it'll assist me in the evidence, if you stand by certain decisions, even now, then it may be necessary to probe them in more detail. If now you regard them as being irregular or the product of, to use some of the words in your statement, a bigger scheme or a scandalous transaction, that will assist me in navigating where to focus in the evidence. So insofar as this decision to mandate you to conclude this transaction with Free State Development Corporation, do you stand by it today?
The answer would be yes and no. When I'm saying yes, if the company continued with the transaction at the time, the company was going to save on interest, because at the time the company was paying an interest of 1.2 billion per year just to service the debt and not to pay the capital portion. So if you look at the term sheet that was submitted by Grisak, looking at that, I would say it would have saved the company. But looking in detail now, after the inquiry at the letter that I received from FDC and analyzing it in detail, it looked like there were previous discussions that were done by FDC, to the extent that already they had a potential investor, foreign investor, which at the time I didn't read in detail because you would also understand that I was 3 days or 4 days in the office. Today, I would say the reason why I'm saying there was a bigger scheme, it looks like there were discussions before the discussion. By saying that, it means already there were discussions to form with FDC a joint venture. There was a discussion already with a potential funder of that, so which happens to be the same funder of Seacrest. So today, then I'm not standing next to it. I'm saying there were bigger schemes and perhaps there were people that stood to benefit from the transaction using me to conclude the transaction.
Well, maybe let's get this clarified. I think what Ms. Hofmeyer is, what her question is aimed at is two things. The first is whether, knowing what you know today about that decision that was made by the board, do you support it, the decision? And in answering that question, you may have regard to a number of things, but part of it includes processes that may have been followed or not followed or should have been followed. So if you look at that decision, how it was taken, and everything that you know today, do you support that? Do you say it was the correct decision that was taken?
No, Chair, it was not the correct decision. It was not in the best interest of the company.
Thank you. If we then go to the decision to appoint BNP Capital as a transaction advisor, as I have it from your statement, you do support that decision. I take that from at page 7, paragraph 23.
Did you say page 7?
Page 7, indeed, Chair, paragraph 23.
Yes, I'm there, Chair.
I would like to clarify, though, because what you say here, in this part you are talking about the decision on the transaction advisor, and you're talking about the fact that there was a decision to appoint a transaction advisor and then a later implementation of that decision. And you say in the third line at paragraph 23, I did not foresee anything untoward when I implemented the board's instruction, because based on the historical information my predecessor used to take instructions from the board and submit an motivation afterwards. I'm going to explore that further with you in your evidence. But in the part that we're at the moment, where I'm simply asking you, as the chair has indicated to you, to tell us whether today, knowing all you know, you still support that decision. What is your answer?
Yes, I still support the decision, Chair.
Thank you. The next one is the decision to extend the scope of BNP Capital from that of transaction advisor to sourcer of funds. Knowing what you know now, do you support that decision?
No, Chair, I don't support it.
Then there is the request for the approval of a cancellation fee to be paid to BNP Capital pursuant to that extended scope. Do you today support that decision?
I never supported it, Chair.
We will have to go to
I guess that means, therefore, you still don't support it.
Yes, Chair.
Okay.
we will pick that up, Ms. Nhantsi, in relation to the recommendation that you wrote to the board to support the payment of that cancellation fee. Chair, that gives me a good background for the purposes of the remainder of the evidence. I see we're just before the tea break, but if it's appropriate, possibly we take it now and then we can return.
Yes, let's take it now. We'll take the tea break and resume at 11:30. We adjourn. both this morning and just now. I've struggled to make it on time because of meetings, but we'll try and improve. Let's proceed.
Thank you, Chair. Ms. Nhantsi, as I indicated before the break, I'd like to now go into some detail in relation to these various decisions, that I've got your evidence in relation to your current position on them. I'd like to start with the decision in relation to the Free State Development Corporation. That was taken at the 3 December board meeting. And we looked a moment ago at the actual resolution, which you found in Ms. Stimple's file, A at page 289. I'd like us just to look at it for a moment, if we may. That's 289 of Exhibit DD1A.
Thank you.
Ms. Timpo, apologies, Ms. Nhantsi, I'd like to just understand whether you understood this resolution in the same way that in the course of the evidence last week it had been understood by Ms. Stimple. At C, what is recorded there is that you and the acting CEO must urgently take steps to negotiate, conclude, execute, sign, and or dispatch all documents and notices related to the 14 billion loan offer received from a potential funder, Free State Development Corporation, as per the letter circulated. What did you understand that to require of you?
Thank you, Chair. I understood that as a mandate that we were given by the board, based on the letter that was circulated on the day. Allow me to give a bit of background as well. When I joined SAA on the 27th of November 2015, on the 1st of December 2015, which is literally 4 days after, I received a call from Mr. Moyo, Mr. Shepherd Moyo, who is the CFO at FDC, who first congratulated me on the move that I made to SAA, and secondly asked me if SAA still needs the funding. Firstly, I would like to declare, which I did on my statement, that I served articles at Sizwenzaluba Kobodo with Shepherd Moyo. We were both audit managers, senior audit managers. By the time he left, he was the senior audit manager, I was the audit partner. So I saw nothing untowards him, one, congratulating me on the move, two, asking if SAA still needs funding, because it was on the public domain that SAA, at some point there was a tender out there that needed funding for SAA. So I responded to say, yes, SAA is still in need of funding. He told me that they can assist. So I asked, how can they assist? He said they can call, one, I asked, how can you assist? Because my understanding is you receive grant from government. And two, do you have a mandate for that? He responded by saying, yes, they are in talks with a foreign investor, and their FDC Act allows them to do the transaction. So I requested him to put it in writing, and I then told him that because it was the first, I said to him, put it in writing, there's a board meeting on the 3rd of December, I will then discuss it with the board, which he did. On the 2nd of the following day, I then received a letter from Mr. Moyo. I'm not sure which page.
It's a page back. If you just go back in Ms. Stimple's bundle, you'll find it there at page 287. Is that the letter you're referring to?
Yes, Chair. This is the letter that I'm referring to. Basically, it says what we said on the call, because I asked him to put it in writing. I'm not sure if I should read it, Chair.
We have seen it before,
All right.
so that's, Chair, as long as you're happy with that.
Yes, no, we have seen it, we have read it, yeah.
So I then, on the first, after I received a call, on the following day morning, I updated the acting CEO, Mr. Zwane, and I received the letter. I shared the letter, I made a copy, I shared it with him. He also agreed that let's take it to the board the following day. And the process to do that is to give the submission to company secretary, which we did. She made copies, and on the day, the letter was circulated. There were many items on the agenda item, but the letter was discussed after the deliberations, long deliberations that were done on the submission that was made on the day. There was a submission that was dated, signed 27 November. I think it was returned on the 26th of November, recommended a company called Secrest by Ms. Timbel. So after the long deliberations on the board, on the recommendation that was made by Ms. Timbel, recommending Secrest to be appointed as a funder for 15 billion, the board raised concerns. One was the rate they felt is a bit high, which was 5.8%. The second one, there was also one of the attachments on the due diligence, where it was said that Secrest refused to give information for the company to do the due diligence, and also the proof of funds. They refused with the proof of funds. So the board, after deliberated on it, felt that because they felt that it looks like if they don't want this due diligence to be done, it was a bit odd, because they felt as if it looks like Secrest wants to get the letter of award and go and source funding. Perhaps they believed that maybe Secrest does not have the funds, therefore it was declined. The second recommendation that was on that submission was the consortium of banks. If my memory serves me correct, I'm not the chair, I'm not sure which page, but it was recommending the consortium of banks to the tune of 4.3 billion.
Correct.
The board felt it defeats the purpose. The purpose of debt consolidation was to maximize and get and pay the lowest interest, because on average at the time, in fact, the accurate amount, the company was paying an interest of 1.2 billion. So they felt if they can put it in one house, they can pay a better rate. So it was then declined, the consortium of lenders, and even the rates that the lenders were giving were the same rates that they were servicing the company at. So the board felt that it defeats the purpose. So they went through the letter. One of the things that I noticed on the board, which I didn't at the time because I was still new, specifically the chair of the board, it looks like she knew about the FDC, and we were then told or mandated, myself and acting CEO, to urgently facilitate and run with the letter and do all the necessary documents because the company urgently needs the funds.
Thank you, Ms. Nhantsi. So is it fair to say you understood that your mandate was to conclude the transaction with FDC?
That was my understanding. As much as that was the understanding, when I joined the company, I always wore the hat of ensuring that the processes are followed. So subsequent to this, after the board meeting, I then called, I think it was Friday, if I'm not mistaken, the 3rd, but I called the procurement team, which was comprised of Mr. Lester Peters and Silas Matsauta, who was the commodity manager at the time. I then told them that the board has declined basically the resolution as we have read, and I asked them, how can we go about ensuring that we implement the board resolution, but at the same time, we are in line with the supply chain management process. We discussed it. Firstly, Mr. Peters' response was more like, this is a board resolution, we should implement it because the board has taken a decision. But we discussed it because I wanted to make sure that at the end, we're acting in the best interest of the company. And Mr. Matsausa even went to his office to bring the supply chain management policy. And there was a clause that they referred me to, which is clause on the SCM policy. I'm not sure what page is the SCM policy, Chair.
I'll get that for you now.
Okay.
I think it is somewhere in your own statement as
It
well. I
is.
think you refer to it in your statement.
It is on page 4 at paragraph 13.
Paragraph, sorry, page.
Page 4 of your statement, which is right at the beginning of your Exhibit DD2 bundle. And you'll find it at paragraph 13 on page 4.
All right, I'm going there. Thank you, Chair. Yes, the SCM policy of 2011 had a chapter 14.4 on the alternative offers, and the subclause 14.4.1 stipulated as follows: regardless of whether the bidder submits an offer conforming strictly to the specification, alternative offers may be considered and accepted, provided that the other bidders are not prejudiced. So this is the clause that we used to ensure that we are in line with the SCM policy, because the other bidders are not prejudiced in this case, because the board already declined Secrest that was recommended. The board already declined the consortium of the banks. So the SCM policy of SAA allowed that we can use this paragraph, this clause to ensure that we comply with the SCM policy, and also we do what is needed by the board, the implementation. After that meeting, following day, I then called the the treasury team, which is made up of Ms. Timbel and Mr. Michael Klein. I then explained what happened in the board, that the board declined Secrest and the consortium of the lenders, and the board then mandated myself and the acting CE to engage urgently and conclude with the FDC. And then I told them that I engaged with the procurement team, and they advised that it is allowed in terms of the SCM policy. I recall that Mr. Klein even wanted a copy of the specific clause of SCM, and he made a copy. In the discussion, Ms. Timbel then was shouting, if I am allowed to use that name, shouting and saying this is not allowed. The FDC was not in the list of the bidders that bidded, and this is against the policy. And why did I go to procurement for funding? Funding is excluded from the policy. It is guided by, I think he said, by the financial risk framework. So we then discussed that, and then I wanted to understand from her, where is the exclusion on the SCM policy? Where is it excluded that the funding is not part of the SCM? I had a reason to ask that question. It's because when we attended the board meeting on the 3rd of December, the board members told me that in the past they made, in fact I also read it on the pack, they made the Treasury Department together with my predecessor to cancel the tender that was done based on the financial risk framework, because it was not following the procurement process, and it was not competitive, it was not fair, and it was not transparent. So she couldn't answer me where the exclusion is, but she kept on saying that the board was wrong in excluding, in declining specifically Secrest, because the company needs funding, which I agreed that the company needs funding. But the questions that I raised to her was, the board had reasons. She wanted the board resolution, which I said she can get from company secretary. And then I explained that the board had reasons why they declined at the time, because the company refused the due diligence. The company didn't want to show the proof of funds. So I then explained to them and I gave them the copy, and then the meeting was ended at the time. But they then updated me, because I said this is the resolution that we need to implement. We then decided together with procurement and treasury team that the best way to do it is to send the are you stopping me?
No, not at all.
Oh,
Sorry.
Is to send the template of the term sheet, and also to send the RFP that was sent to the other bidders to FDC. They requested me for contact details, which I gave Michael Clay, Mr. Clay, and Ms. Timpel the contact details, the cell number of Mr. Shepherd Moyo, and they were sent. And Mr. Shepherd Moyo was given a deadline of 24th of December to complete the term sheet, which he did. The term sheet was received back from FDC on the 24th of December 2015, and it was evaluated early in 2016.
Thank you. Apologies. Please continue if there's more.
Yes. One of the things that I highlighted, that I noticed on the term sheet was it's coming from the funder is the same GRISAC that was a proposal for Secrest. Secrest as well, when it was recommended, the funder was GRISAC AG PT1 Ltd. Now with FDC as well, it was GRISAC AG PT1 Ltd. So I remember one day when Ms. Timpel again came to my office, still shouting that the board took a wrong decision, because now the company is going to be in default. She does not understand how the board was meddling with the procurement processes. They should have accepted and approved Secrest. So one question that I asked Ms. Timpel was, if you look at the rates that the same funder is giving, when it was Secrest, it was 5.8%, the interest rate fixed. When it was FDC, the interest rate was still fixed, but at 4%. So I asked Ms. Timpel, did she consider I understand that it was not part of the, FDC was not part of the bidders that submitted and followed the process, as much as now it's accommodated on SCM, but did he consider that should the company have taken Secrest, the company was going to pay 1.8% more than if it takes FDC? And 1.8% of 15 billion is about 270 million rands. So that's where I looked at, because, Chair, I would like to say, at the time that I was running the transaction, I think the end results was what I had in mind was there are loans that are maturing. And we had weekly meetings with the banks together with National Treasury. And on all those meetings, the banks, both local and international, they expressed the anxiety. They wanted their exposure to be reduced, to the extent that they even wrote to the DG of National Treasury, wanting, because they said at the time they were raising two issues. They were raising the fact that the company's performance is deteriorating, and to the extent that they feel that they are funding the operations of the business, the day-to-day operations of the business. And they were saying it's not supposed to be like that. And they were true, because if you go and loan money just to pay salaries, it's not sustainable. So they even said to the letter to National Treasury in the meetings, they are now feeling as if they are the shareholders of SAA. They want shareholder to come to the party. The second issue that they raised was around governance, where they said there are so many people in acting positions. Basically, they felt that there's no accountability because when you are acting, there's no really accountability. The third concern that the banks consistently raised at the time was I used to say the three-man board, but the board members, there were only 3 board members. So they felt if the board could be beefed up, they believed that then in terms of governance, that would be done. So at the back of my mind, I had that. And the banks at the time, they told us that they will never, until all these are resolved, including capitalization from the shareholder to SAA, they will not extend or roll over the loans beyond 3 months. And in the 3 months that they were giving the company chair, every expiry of 3 months, they were including a margin, meaning the interest rate was increasing. So the interest rate was increasing. The interest rate was increasing now to be beyond the 1.2. So there would be a point where the company would not even be in a position to service the debt. So at the back of my mind, being appointed as an interim CFO, I had that in mind, that one of my duties was to pay debts as and when they are due. So we had this 1.2 billion that is servicing the debt. So when I looked, one thing that caught my eye on the 2, before I even asked who is Grisak, one thing that caught my eye was the difference on the interest rates from the same funder. One, if we took 5.8% and the other one is 4%, and the company would have paid 270 million. So at the time, those were the things that I was looking at. In fact, I even did a calculation which I presented to the board, where high level, I then looked at the rates that the company was currently paying, and now if we pay 4%, I think the interest on saving was 700 million. So that was the ultimate goal, to say if we do this, also if we do it within the ambit of law, together in line with the SCM policy, the company would pay 500 million on interest and save 700 million on interest, Chair. So we received the term sheet. The Treasury team, the committee then evaluated between now the preferred bidder, which is Secrest, and FDC. FDC was then won because of the rate. I recall I had a meeting with the FRST team where they told me now this is in January 2016.
Ms. Nhantsi, do you mind if we pause there just for a moment?
Okay,
Because there's an extreme amount that you've covered in relation to just a crisp question initially, and I'd like to unpack it before we get to January 2016.
All right.
Right. Let's start with the procurement policy needing to be followed.
Yes.
You gave us background as to the board's view that it should be followed, notwithstanding Ms. Stimple's view that funding might have fell outside it. Mm-hmm. So do I have it that you regard it as applying to this procurement process?
Sorry?
You regarded the supply chain management policy as applicable to the sourcing of funds?
Yes.
Thank you.
Just before you proceed, Ms. Hofmeyer, you mentioned that earlier on, whatever happened in December 2015, you were still quite new at SAA and so on. But yes. I just want to ask this question. At that time, how long had you been a chartered accountant?
That was 2015. I qualified in 2007, Chair. So in 2015.
So it's from 27, it's about what, 8 years?
Yes.
7, 8 years.
Yes, Chair.
And during most of those years, you were at Sizwe and Saluba and Kobodo?
Yes, Chair.
Okay, no, that's fine. I just wanted to get that context. Thank you.
Thank you, Chair. You indicated in your answer that you were advised by the commodity manager and Advocate Lester Peter that you could use clause 14.4.1 of the supply chain management policy for the purposes of now implementing the instruction that you'd received from the board on the 3rd of December to conclude the transaction with FDC. Is that correct?
Yes, Chair.
I'd like to just debate that clause with you. I know that you're not a lawyer, but I
Okay.
need to put to you that there is an entirely different interpretation of that clause that
Okay.
would not have supported the extension to FDC at that point. You will find the full supply chain management policy in Ms. Stimple's bundle, but I'm happy to work off the excerpt that you have in your statement because there's nothing else in that clause.
Okay.
Well, as I say that, I realize actually locating it in the policy is quite important.
Okay.
So let's go to it. It's in Ms. Stimple's bundle, and it's C. It's Exhibit DD1, but File C of that bundle.
Okay.
Is it in the Lever Arch file that has got Ms. Stimple's statement?
It is indeed, Chair, but in Division C of that,
Division C.
it's the last of them. So you'll be looking for DD1 small c. And you'll
Okay,
find
that's
it,
Exhibit DD1C.
indeed, Chair.
And what page?
Just to orientate everyone, the policy begins at page 868, but the relevant clause is at page 894.
894.
Yes.
Thank you.
Yes, I'm there, Chair.
Ms. Nhantsi, just to orientate you, this supply chain management policy goes through, it tracks in essence the various stages of the procurement process. Are you aware of that?
Yes.
Yes, because as I had your evidence earlier, you said your role at SAA was to ensure that proper processes were followed. Is that correct?
Yes.
Right. So you'd be familiar with this. It goes through the various stages of the evaluation process for bids, and then you get at page 894 to a heading called Evaluation Process. Do you see that?
Yes.
So this is evaluation of bids that have been received and for which there are requirements in the preceding clauses of the SCM policy. Do you accept that?
Yes.
So when you get to 14.4, which talks about alternative offers, and it reads as follows: regardless of whether a bidder submits an offer conforming strictly to the specification, alternate offers may be considered and accepted, provided that other bidders are not prejudiced. Now, FDC was not a bidder in the prior procurement process that was embarked upon by SAA, was it?
No, it was not.
That RFP had an opening date and a closing date by which bids had to be submitted,
Yes.
correct? So when I want to suggest to you that when this clause of the SCM policy is talking about alternative offers from bidders, it is envisaging bidders who have complied with the procurement requirements, which are that they bid within the time period, and then it makes available the prospect that you could accept an alternative offer from such a bidder that did not comply with the specifications of the bid, provided it didn't prejudice others. Do you see that as a possible reading of that clause?
As you have rightfully said, I'm not a lawyer, and procurement advised me that this is the alternative, because how I read it, as I've declared that I'm an accountant, for me, it reads and say alternative offers may be considered and accepted, provided that the other bidders are not prejudiced. How it was interpreted to me and how I understand it is, even if you didn't form part, you didn't submit, but if it's an alternative offer, it can be accepted by the board, provided it does not prejudice others.
I understand that that is what you were informed of at the time, but do you accept that in the scheme of proper procurement,
Yeah.
where there are opening dates and closing dates for bids, and people have to get their bids in that time, which the preceding parts of this policy refers to,
Yes.
when it is now talking about bidders, it's talking about bidders who participate in that process?
It's not clear, Chair.
Ah, okay. Well, that...
Do you accept that if you interpret the clause to mean that you could accept a proposal from somebody who did not submit a bid within the time stipulated, do you accept that that interpretation could defeat the purpose of having a date when it's open for bidders to put in their bids and a date when everybody's told it's now closed? If you come after, you are too late. Do you accept that that interpretation could defeat that entire purpose?
I accept that, Chair. But also how I interpreted it is now that process of bid opening and closing came and gone because the recommendation came to the board and the board then declined. So I then, when the board said then engage with FDC, how I interpreted it is within this ambit of this clause that it is in line, we can go and engage the FDC. Yes.
So your understanding of it was that it allowed SAA to take proposals or bids from even people who did not put in bids within the time.
That's my understanding.
That's how you understood
That's how I
it.
understood it, Chair. And also, what I also checked as I was doing it, I was reading this was to check what is the mandate or what is the role of the board on the SCM, which is catered on the same SCM policy, section 6. If you allow me to go there, Chair.
Yes, yes.
On page 881.
Yes.
Page 881 under 6.2.2. It talks about the board. 6.2.2.3. It talks about the board will approve all SCM transactions which are in line with their delegation of authority, and on request any other transaction of lower value as it deemed fit. So reading that the board will, this transaction was within the purview of the board, and now it is the board that is accepting an alternative offer, and my interpretation was it is in line.
Okay. It's
Apologies.
me. Okay, thank you. You may proceed.
Ms. Nhantsi, you'll accept that what the board decided on the 3rd of December was not to follow any procurement process, was it?
Yes.
They just wanted you to conclude the transaction with FDC.
Yes, yes, Chair, you are right. But I decided that for the benefit of the company and to act in the best interest of the company, I would follow the processes.
Indeed, but the
Yes.
accounting authority of SAA was not concerned with proper process being followed.
Yes, Chair.
Thank you.
Well, I'm sorry. You just accepted a proposition that the board did not follow any process, but that might be so. But was your understanding that the policy allowed the board to do exactly that? Was that your understanding, or that was not your understanding?
At the time, the 3rd of December, I was not aware of what the policy caters and what the policy doesn't cater. Hence, Chair, after the board meeting, I couldn't tell the board that don't give me this mandate and we need to go follow the process first.
Yes.
But after the meeting, I called the procurement team and say this is what the board is saying we must do, we must implement. Hence I said, Mr. Lester Peter said, let's just implement because the board has taken a decision.
Yes.
But I was adamant, I felt uncomfortable, Chair. I wanted to follow the procurement processes.
Yes.
I understand that throughout this transaction, I did things in reverse because the transaction itself fall within the ambit of the board. They take a decision, but I went back every time to follow the procurement process.
Okay.
Thank you, Chair. I'd then like to just pause in relation to your evidence on Seacrest and its margin on the GRISAG offer, because I understood you to say in your evidence, and you'll correct me if I'm wrong, that you accept that at the time that Ms. Stimple, in November of 2015, recommended as head of Treasury at the time that Seacrest be approved, she was not aware of the underlying GRISAG percentage. Is that right?
When you're saying underlying percentage, you mean she was not aware of the FDCs and the others?
No, not FDC. I'm saying insofar as the Seacrest bid was concerned,
Yes.
Seacrest was going to receive its funding from GRISAG, correct? But at the time, the 27th of November, all that had been presented to the those evaluating the bids that had come through was a Seacrest bid at 5.8%,
Yes, I
correct?
agree. Yes.
So she did not know at the time what portion of the 5.8% was going to be paid to GRISAG, correct?
Yes, I agree.
So she couldn't be criticized for being comfortable with 1.8% at the time, because she did not know at the time that the Seacrest margin was 1.8%, correct?
You are correct by saying at the time.
Thank
Yes.
you.
Maybe don't sit too far away from the microphone, or bring it closer if you want to.
Apologies,
Sit back,
Chair.
so that whatever you say will be recorded.
Apologies, Chair.
Ms. Nhantsi, just for the record,
Perhaps can I expand when I'm saying you were right when you say at the time? Ms. Timber, yes, even myself in January, because the reason why I said in January, I raised the concern of the rate in January. And in January, it was after we received the FDC term sheet. And the
Indeed.
FDC term sheet had 4%.
indeed. But you didn't actually know what the GRISAG percentage was on the Seacrest deal, did you?
I knew.
No, because what you'd seen at the time, as I have it, is the GRISAG term sheet when they were to join forces with FDC.
With secrets. On the memo itself, the one that was submitted to the board, there was a table that was showing the rates.
Indeed, that only referenced Seacrest at
And-
5.8%.
Agree.
Would you like to go to it? Because the one point I'd like to make in relation to it,
Yeah.
you said that one of the reasons that the board was uncomfortable with Seacrest was the rate of 5.8%. Do you recall saying that?
Yes.
That is not recorded as one of their given reasons. Do you accept that?
Yes, it was in the discussion item. In fact, it was the point that was raised by the chairperson of the board.
Did you raise with her when she made that point that Seacrest was the cheapest at 5.8% of all the bids that had been received?
No, I didn't raise any issue at that time, as I did not have the information at hand in terms of what is the average rate that the banks are charging at the time, because I was in day 4 on my job.
Well, it wasn't the average at the time, it was the submission from Group Treasury
Yes.
to which you made reference, dated
Yeah.
the 27th of November, that served before the board at that meeting. Do you recall that?
Yes.
So it would have been part of the board pack.
Okay.
Let's go to it, just so that we can look across at that table.
All right.
It is in Ms. Stimple's Exhibit DD1A, and you'll find it at page 256.
Sorry.
256.
6. Yes.
Okay. Yes.
Yes, I'm there.
Do you recall this table, Ms. Nhantsi?
Yes, I do.
So you'll see there at the pricing section towards the bottom, the base rate of the various bidders is set out there. When I said Seacrest was the cheapest, I should have been slightly clearer. It's the cheapest who were offering the 15 billion, which seemed to have been a concern both for you and the board. Do you accept that?
Yes.
So of the bids they received, Seacrest was the cheapest. Do you accept that?
Yes, I do.
And there was no confirmed interest rate that would be charged by FDC at the point in time that the board decided to reject the Seacrest offer or the alternative offer. Is that correct?
Yes, correct.
Thank you.
But it is the point that was raised by the chairperson of the board in the meeting.
Understood. What I was trying to clarify was whether anyone interrogated it when it was raised.
No, I did not interrogate it, Chair.
Thank you. And then I'd
I'm
like...
sorry, are you saying the chairperson of the board informed the board meeting what the interest rate would be that FDC would charge?
No, Chair.
That's not what you are saying.
It's not what I'm saying, Chair.
Okay.
What I'm saying is, she said she raised a concern that the 5.8 might be high, but she didn't say compared to what.
Yes.
Ms. Nhantsi, but you'll accept compared to the bids that were before them,
It was the cheapest.
it was the cheapest.
Agree.
Thank you. I'd then like to just deal with the first reason that the board is recorded as having given for rejecting the Seacrest bid. That had to do, as I understand your evidence and is reflected in the documents, with their unwillingness to provide their source of funds and concerns around the due diligence. Is that correct?
Correct.
Did anyone raise with the board that legal had looked into this and had created a series of protections for SAA in the conditions precedent that had been designed for the agreement that would be concluded with Seacrest?
It was discussed, it was raised, but the board was not comfortable with the fact that you will enter into an agreement, yet the company, you don't know the company, they are refusing with the information. Hence, they felt that it looks like Seacrest does not have money. They want the letter of award so that they can go and source the funds. So they were not happy with the condition precedent because it was there to say Seacrest must be accepted with the condition precedent that they submit the documentation. So the board was not comfortable with approving, yet the due diligence is not yet completed.
Was there a representative of SAA Legal at that meeting?
I don't recall, Chair, whether the legal person was called or acting CEO discussed this, but it was not me.
Can we then understand that this determination by the board of the inadequacy of the conditions precedent that had been proposed by the legal review
Yes.
was not canvassed with anyone from the legal department?
When you're saying was not canvassed, you mean nobody was called in?
Indeed.
Yes, nobody was called in. Acting CEO took them through.
Do you have a view on whether those conditions precedent would have been adequate? And just before you answer that, if I may just give the background, we went through them in some detail with Ms. Stimple, but what they appeared to do is to allow an agreement to be concluded with SAA subject to conditions precedent that would have required all of that information which wasn't forthcoming prior to that point to then have to be provided before the agreement would take effect. Did you consider that at all in the advice you gave to the board on the day?
Chair, first, I didn't give advice to the board on the day. But the board, as I'm saying, the board was not comfortable, specifically as it is written on the board resolution. They were not comfortable because of those two instances, and they didn't call a legal person to come in and explain. They declined it.
Just one more clarification. Did they raise at all the conditions precedent that had been proposed?
I don't recall. I think what was on debate on the day, or what was discussed, is the fact that Seacrest is refusing with the proof of funds and the certain information for legal to complete the due diligence.
Were you aware at that time yourself conditions precedent that had been suggested?
I was not aware, Chair.
And do you know whether the documents setting them out had been placed before the board?
I don't recall the
don't
draft
recall.
agreement, Chair,
Yeah.
on the PEC
Okay.
that was submitted to the board.
All right. In terms of what the board was told about Seacrest, do you know whether there was a memo or a document which was speaking to Seacrest's bid in detail?
There was a memo, Chair.
Yes.
Yes,
And was it a memo that you had had a chance to read before you came to the meeting?
yes, Chair.
And you say it did not have those
draft
conditions
agreement.
precedent?
No, Chair. If I recall, the memo was explaining the process that has been followed from the RFP and was explaining the bidders that have submitted their bids, and the
Yes.
evaluation was done. And based on this table, the recommendation was Seacrest, and it was also, the same memo was then highlighting the urgency of the funds that the
Yes.
company needs. It was even highlighting the liquidity risks that company, together with the catastrophic risks that the company would face should the company not get the funding. Yes.
Ms. Nhantsi, I'd like to assist, if I may, in this regard.
Okay.
Because our understanding from the evidence that's been presented thus far is that both the 27 November submission from the group treasurer was before the board, but so too was the memo that recommendation had required be done by the legal risk and compliance section. I'll take you to those documents now, to which an annexure is the draft agreement with the conditions precedent. So maybe that'll help refresh your memory as to whether that's served before the board.
Okay.
You'll find that in DD1 at page 244.
DD1A,
1A, apologies, yes. Way A,
page
244. Apologies, I think I got that wrong as well. 244.
Yes.
I think that's the memo you're recalling. Is that right?
Yes.
So this is the group treasurer memo of 27 November. It is written, well, to get the chronology exactly right, there's one that precedes this, which recommended a DD be done. There was a DD done, and it is dated, you'll see it at 274. It is dated 26 November because, Chair, you'll recall from the evidence there was concern.
I just want to say there are so many of these acronyms.
Indeed.
That's due diligence you're talking
It
about.
is, it is. DD, for present purposes, means due diligence, not the exhibit number that we're
Yeah.
currently dealing with.
Yes.
So, Ms. Nhantsi, you'll see at 274, that is the SAA EXCO submission prepared by Legal Risk and Compliance.
Yes.
Do you recall seeing that at the time?
In the board meeting,
You see, this is what covers all of the concerns of the
Yeah.
legal department about that due diligence. It deals
yes,
with...
yes, I saw it. It was part of the 27 November.
Okay, well then you'll see at page 275, in the second line, the sentence starts there, a draft agreement has been prepared for the proposed transaction with Seacrest. A copy is attached marked Annex 2. That's the one that contains the conditions precedent.
Yes,
So you satisfied that was also before the board then?
yes.
Thank you.
But I don't recall it, yes.
Thank you. I'd like to then just ask a few concluding questions on the FDC decision.
Okay.
Ms. Nhantsi, as I have your testimony earlier, you even raised on that call with Mr. Moyo on the 1st of December an issue around the mandate of the FDC. Is that correct?
Yes, it's correct, Chair.
And as I understand your evidence, he told you in no uncertain terms it was within their mandate to engage in this funding. Is that correct?
Yes, Chair.
You were then informed, and I did interrupt you earlier, apologies for that, but I wanted to move in sequence to January 2016, because you were about to get there.
Okay.
And as we have Ms. Stimple's evidence, on the 6th of January 2016, she relayed to you the outcome of a meeting that had been had between the Treasury Department of SAA and National Treasury, at which National Treasury had indicated that this funding was beyond the mandate of the FDC. Do you recall that?
Yes, I recall.
You recall her making that known to you on the 6th of January?
Yes, and also I then said I will come back to her
Correct.
on that.
Indeed.
Yes.
On that, you seem to be agreed in your evidence.
Yes.
Did that not worry you? What did you do when you said you'd come back to her?
Yes. I did call the CFO of FDC, as I've said to Ms. Timbel that I will go and find out. And then I even specifically asked Mr. Moyo which section on the Act of FDC are they mandated to do. He referred me to section 4AH, which is on the powers of the board on the FDC Act.
Oh, well, let's look at that if we may. Chair, we do have it in the bundle.
In which bundle would it be?
Just have to remind myself. Yes, it is in DD1C.
I've got Exhibit DD1C.
And you'll find the Act begins at page 904.
904.
Sorry, what's the page?
904. Ms. Nhantsi, can I just ask a little bit more about that conversation? When he referenced that section of the Act, did you go and look at it yourself at the time?
Yes, I did.
You said that he'd indicated section 4F.
4A, subparagraph H,
4 capital
for
A.
capital A, small letter H. It starts by saying the board of directors shall have all the powers to achieve all the main objects for which the corporation is established, and without detracting from the generality of this section, the powers of the board shall include the following: to enter into and finance joint ventures or act as an agent.
Ms. Nhantsi, I'll probe that a bit further with you, but can I just check,
Yeah.
did you run this past anyone in legal at SAA?
I discussed it with the head of legal, Eshela Fikelepi.
When was that?
Sometime in January, after I discussed it with Mr. Moyo.
Did she agree with your interpretation?
Yes, she did, but it was not, I didn't ask for a legal opinion. We were just discussing.
We'll come back to why a legal due diligence wasn't done, because that was actually requested in December by somebody from the legal department.
Okay.
Ms. Nhantsi, I accept that you are not a lawyer, indeed.
But can I explain why I accepted this and the discussion that I had with Ms. Fikelepi?
Indeed.
Because the board has got powers to enter into finance, joint ventures, or act as an agent. The discussion that I had with CFO of FDC, I asked how are they going to benefit or how are they acting. He said in this transaction they're going to act as an agent because they don't have the funds. The foreign investor, in this case is Grisak AG, will give the funds, but they will charge a margin at SAA. So basically they're acting as an agent.
So let me just get the sequence of events right. You
Yeah.
were told on the 6th of January that National Treasury had taken the view that this was beyond the mandate of the FDC, correct?
Yes,
You then went to engage FDC yourself, correct?
Yes.
You were told by FDC that National Treasury was wrong, that in fact it did fall within their mandate for
Yeah.
capital AH,
yes,
correct?
yes, Chair.
You had a conversation with somebody in the legal department but didn't ask for any formal review to be done of this question, correct?
At the time, Chair, I didn't ask for it.
Didn't worry you that the advice you were being given was directly contradicting what National Treasury had said?
Not really, Chair, at the time, but now looking back and having heard what I've heard up to so far, it would worry me, but at the time it didn't.
Ms. Nhantsi, I accept you're not a lawyer, but I must put this to you in fairness. The powers of the board of directors of a company cannot be greater than the capacity of the company. That's why a lawyer looking at this would first start at the capacity of the company, which is Section 4. We did this the other day with Ms. Stimple in her evidence. You may have seen that. The capacity of the corporation in Section 4 is defined with reference to its main objects, which is in 3, and none of those Sections 3 include lending between state-owned entities. They are all specifically concerned with the province of the Free State. Do you see that?
Yes, I see that. But as I'm saying, he also referred me to this section, which I read, and it made sense to me, and I discussed with Eshela Figelepi. But at the time, I didn't think of getting the legal opinion. But as you rightfully saying, it shouldn't have exceeded the capacity. I don't know, and thanks for that. I didn't know.
Right,
I'm sorry. Did it cross your mind that it was strange that an entity that is supposed to operate within a province, Free State, was seeking to involve itself outside of the province and with SAA? Is that
Yes,
something that crossed your mind as
It
rather
did.
strange?
It did, Chair. I even asked, and allow me to put in layman term because he's also not a lawyer. I asked I said to him, it's a public knowledge that FDC gets grant from government. Where you gonna get 15 billion from? And then he told me about the foreign investor. I then said, how is FDC gonna benefit? He said, no, in terms of their FDC Act. That's why I'm saying, allow me to put in layman's term, because he then said the Act allows them to think outside the box and get money for Free State Development Corporation. And how they're gonna get money from this is there will be this intermediary, and I think he said 0.5% will be earned by FDC doing this transaction. Therefore, FDC is gonna benefit. So it made sense to me, Chair.
Ms. Nhantsi, how long after National Treasury raised this concern of the mandate of the FDC continued to be entertained as a possible source of funds becomes quite important in relation to the urgency with which funds eventually had to be sourced when FDC and that transaction fell through. I'm giving you that background because I want to put to you that if Mr. Lusenga's query on the 11th of December that a legal due diligence needed to be done on FDC had been done. Do you recall that he made that request?
Yes, I did.
Would you like to go to the email containing it?
I remember it, but we can go if...
Okay, it's in DD1A at page 303.
Yes, I'm there, Chair.
DD1A, page 303.
Yes, I'm there, Chair.
Thank you.
Yes, of course. Thank you.
Thank you, Chair. This is an email we looked at in last week's evidence. This is after the board's decision on the 3rd of December to transact with FDC, and then as I have it, your efforts then to run a process for the procurement of FDC, despite the fact that the board had already taken its decision. And in response to the sending out of the RFP to FDC, Mr. Lusenga, who I understand is from the legal department in SA, is that correct?
Yes, correct.
He sends an email on the 11th of December addressed to Michael Klein. Dear Michael, are we going to conduct a legal and financial due diligence on FDC? Do you see that?
Yes, I do, Chair.
Ms. Nhantsi, I can't resist saying that does come something of an irony to me, that question asked on the 11th of December, because you'll recall one of the principal reasons for the board not being willing to go with Seacrest was that it was not satisfied that an adequate due diligence had been completed, and yet it approved FDC without any due diligence of any sort being done. Do you accept that those are the facts?
Yes,
Because
that's the fact.
the first time this is asked is on the 11th of December. So he asks for it to be done, or whether it's going to be done, and your response at the top of that page, as I have it, is, yes, we will perform the legal due diligence, and I would suggest that we give that mandate to Ursia at the legal department.
Yes.
But that didn't happen formally, did it? According to your evidence.
I don't recall getting any legal due diligence report.
Indeed. All you had was that conversation with her, is that right?
Not conversation, this is a mandate to
No,
giving to
apologies. Your previous evidence was that you had a conversation with her in early January to check what
Oh.
you'd been told by FDC, correct?
No, but that one was more relating to the mandate, but it was not saying she must not do due diligence. I was just asking about the FDC mandate. So this one is mandating the legal department to do the due diligence.
Yes, maybe we're at cross purposes. I assume one of the questions that the legal department would have looked at, had it done this due diligence, is whether it fell within the FDC's mandate to be engaging in this transaction at all.
Yes, as I'm saying, I'm not sure, I didn't get a report from legal department, so I'm not sure what was covered.
Right.
But it was done at legal, Chair.
Indeed, but at least in January 2016, you were happy to proceed with FDC, as I have it, based on what Mr. Moyo had told you about the capacity of FDC and a conversation that you had with the head of the legal department at SAA, correct?
Yes, I was happy, Chair.
And those engagements with FDC, as I have the evidence, continued right up until April of 2016. Is that correct?
Yes, Chair.
Ms. Nhantsi, do you accept that if a proper legal due diligence had been done early in January, or indeed National Treasury's position on this had been accepted, there would have been an opportunity then and there to go out for another source of funds?
Yes, I agree.
So when the FDC has continued to be entertained until April, at least the months of February and March are lost for the purposes of sourcing funds.
Yes, Chair, can I also elaborate on that? It's not just about entertaining FDC. It was more about also calculating, as I said, the interest rate that we were going to get from FDC, which was 4%. So when we continued with FDC, I think in my mind, I saw I was acting in the best interest of the company, looking at the interest rate that we're going to get. Legal department was doing their part, but from the numbers perspective, for me, it made sense to continue with them.
Indeed, Ms. Nhantsi, but whether the FDC had legal capacity to enter into this is a fundamental requirement for this to have been a successful source of funds for SAA, isn't it?
Yes.
So I just reiterate the point. If the work had been done early on in January, or if National Treasury's view had been accepted, that would have been the end to the engagement with FDC, would it
Agree.
not?
Agree.
Thank you. I then like to go to the second decision, which is the decision on the transaction advisor.
Perhaps before you leave that, on my statement, if you allow me, Chair, to conclude, because my answer was no, knowing what I know today, I would like to say why, because I thought you would ask me why today I feel that that decision was not supposed to be made.
Yes, deal with that, please.
Yes. Chair, in my discussion with Mr. Moyo at the time, he mentioned that the chairperson of their board, meaning FDC board, was the sister of Mr. Ace Mahashule. And at the time I couldn't link anything because purely I was coming from the professional background where we're doing the audit and that. So I was not really clued up with politics, but now looking back and knowing what I know, having especially the testimony of Mr. van der Merwe, I see that in a way I was used as a scapegoat or as a vehicle for people to enrich themselves. Because knowing what I know now and also reading again and again the letter that, the one-page letter that we received from FDC, it does appear that there were discussions before the discussions. It leaves me with no choice but to conclude that perhaps they used Mr. Moyo to come to me because I wouldn't question a letter that is coming from Mr. Moyo, because if it was anybody else that I never knew before, I was not going to entertain it. So I feel, Chair, that knowing what I know now with Mr. van der Merwe, I was used in this transaction and the following transaction, but I will talk about the following transaction at the time as well. But one, I was acting in the best interest of the company, running like headless chicken to save money for the company, but not knowing that at the end there are certain people that will have rich pockets.
This decision of the SA board that you and the CEO, was it acting CEO, you were interim CFO and
Acting
there
CEO.
was acting CEO,
Yes, Chair.
that you go ahead and take all the necessary steps and conclude an agreement with FDC. I know that you don't support it now. As you sit there, you say it was not correct, but at that time, I just want to make sure I understand, at that time, did you feel that it was a correct decision?
Yes, Chair. At the time, I felt it was a correct decision, especially also backed up by the numbers.
Yes, and when you look, and your reasons at the time for taking the view that it was the correct decision would be what?
The reasons, Chair, at the time, number one, when you look at the letter that we received, the term sheet that we received from FDC, and you calculate how much savings would the company benefit. Number one, the company was going to benefit 700 million. Number two, I was also comfortable with the fact that, one, this is the board transaction, but I was comfortable that it was accommodated on the SCM policy. We followed the process. So at the time, I thought we're doing a very good thing, and in fact, will be in the books of the company that we saved 700 million in a year.
But you attended that meeting of the board, didn't
Yes.
you? Yes. And as I understand your evidence, you only found out about this clause of the policy after.
Yes.
So at the time the decision was taken, you didn't know that there was a clause that seemed to, or that was going to be said to authorize that
Yeah.
the board makes decision in the way it made it. But at that time, did you think that the board was correct in making the decision that it made, namely go ahead and conclude an agreement with FDC for the provision of this funding without any process
No, Chair.
at that stage as you were sitting at the meeting?
As I was sitting in the meeting, Chair, I knew that I'm going to follow the process
Yes.
and ensure that it is in line with the supply chain management, supply chain policy.
So as you were sitting at the meeting, you didn't know whether it was in line or it was not in
No, I
line?
was not aware, Chair. Hence, I called the procurement after the meeting to say this is the decision that has been taken by the board. The board is saying we must implement this. Is it catered? Is it in line with the policy? Because if it
So-
was not, Chair, I was going to take it back to the board.
So would it be correct that therefore you couldn't have been in support of the decision as at the time you attended the meeting because you didn't have enough information?
I didn't have enough information, Chair. And at the time, I didn't have also any reasons to doubt the board that they are not taking the decision that is in the best interest of the company.
Yes, but when you talk about any decision being in the best interest of a company, there may be two components to that. There might be a decision that in principle may be in the best interest of the company, but there might be also the issue of processes, whether the right process is followed. So I guess that you would look at both before you conclude whether you say this decision is in the best interest of the company, because if the right processes are not followed, that might not be in the best interest of the company.
Agree.
Yes, but are you saying that as you were sitting at the meeting, you didn't know whether that decision was in accordance with the processes, but you assumed that the board would not take a decision that was not in accordance with processes, or
Yes.
what is your evidence?
I assumed, number one thing that I knew at the time, Chair, was in terms of the delegation of authority. This transaction is the board's decision, because I knew that any transaction that is above 50 million rands, the board needs to take a decision. So when they took a decision in declining the secrets and the consortium of the banks and taking a decision of us engaging with FDC, I thought at the time the board, I didn't have any reason to believe that there's anything untoward.
So at what stage or when did you say, would you say you had reached a point where you said, no, this decision of the board is correct?
After I engaged with the procurement team, and they said there is a clause that allows the accommodation of the FDC letter.
Shouldn't there have been certain information before the board about FDC that was critical for its decision that wasn't there? Did the board have all the information that it needed to have before it could make the decision that we are choosing FDC to be the one to
No.
provide funding? Because they were saying, go ahead and conclude an agreement, isn't it?
Yes, Chair.
Yes. Did they have all the information that you, in the position in which you occupied, thought they needed to have?
No, they didn't have all the information, Chair. The only document that was in the position of the board was the letter that we circulated in that morning that was talking about FDC. And the letter, the reason why I thought there's nothing untoward, because that's unsolicited proposal. So the unsolicited proposals, because there was no commitment on that letter. They were saying, if you are interested, there's no firm commitment, but we can engage it further. Hence, after the board, yes, I agree with you, maybe the board took the decision with not enough information on their hands.
But I take it that you, not being a member of the board, but being interim CFO, that your being at the meeting of the board on that occasion included that you could advise the board or alert them to any dangers in making a decision one way or another on a matter such as this. Was that not part of your job at that meeting, namely to to be able to say to the board, before you make any decision on these matters, it's necessary to have the following information. And I note that you don't have that information. My advice is that you don't make a decision until you have that information. Wasn't that part of what you were supposed to do?
It was, Chair, but considering that I was new, they took the decision. But hence I'm saying I went back to the team as far as getting the term sheet to understand what is FDC offering. But you are right, I didn't raise a concern with the board, but in their fairness and in my fairness as well, the fact that the company needed funding urgently, I thought the decision was taken on an urgent basis that go and engage this process that the company had embarked on, had failed. Now this is the unsolicited proposal. Go and engage and conclude if the information surface. That was how I interpreted it.
Well, that may be important because I noted when we looked at this extract from the minutes of the meeting of the board that paragraph 3 of the resolution of the minutes that we looked at 289.
Yes.
You don't have to go there. Didn't say something along these lines. The interim CFO and the acting CEO are mandated to look into the following issues, and if they are satisfied that those issues are in order, go ahead and conclude. It said you must go and conclude. And that struck me as strange in circumstances where it seemed all that they had on before them in regard to FDC was just that letter. But from what you have said, you agree that they didn't have all the information that they needed to have in order to make that decision.
Agreed, Chair.
And you should have advised them. Do you agree?
Agreed, Chair.
And you didn't advise them.
Yes, Chair.
And why is that?
Chair, at that point in time, one, and I don't want it to be seen as if it's an excuse that one, I was new, and it was the first board meeting that I attended, and I didn't know how they operate. Hence, I did not just take it, Chair, and implement. I took it and discussed with the teams and find ways of working on it. And if there were any problems, I would go back to the board and say, yes, you mandated us to run with this, but here are the challenges.
What information wasn't before the board that you believe was important to have been before the board before they made the decision to say conclude an agreement with FDC?
Specifically, the information that was not in front of them was the quantum, was the amount that FDC, because the letter is silent on how much FDC would bring on the table. So the first one is that, and the second one is perhaps if they were more transparent on the funder, and perhaps if they would also be more transparent of whether the FDC Act mandates them to do this. It would have also saved time.
And in terms of due diligence, was that applicable or not applicable?
Not at that point, Chair. The due diligence was going to be done after, because remember, this is the day that we introducing FDC with the unsolicited proposal. So some certain documentation would then come later, but at a minimum, on that day, the letter should have included the quantum. The letter should have been more open on their potential foreign investor and perhaps the tenure of, or the intention, how long would they give, how much is the long term of this debt, the interest rates and all that. But due diligence at the time, Chair, was gonna be done later on.
Well, I might not understand this. My understanding is that paragraph 3 of the extract from the minutes, my understanding is that it includes that it included that you and the acting CEO should conclude an agreement with FDC. Is my understanding correct? Is it
It's
the same as
correct,
yours?
Chair. It's correct, Chair.
But I would have thought that due diligence is supposed to happen before you conclude an agreement.
No, sure, I hear you, Chair. I thought you asked me what information should have been before the board on that day for
Yes,
them
no,
to
no.
decide.
I asked you that question earlier.
Oh,
And
okay.
then you told me what information
Okay.
you thought should have been before the board. Then
Yes.
I asked you the question whether due diligence should have been done before the board could make that decision.
Yes, Chair.
And I thought you were saying, no, not
No,
at
I
that
say-
stage.
Oh, sorry, Chair, yes. Due diligence.
It was supposed to have been done,
Agree, Chair.
and it wasn't done
No,
at
it
that
wa-
stage.
It was not done at that stage, Chair.
And is that quite a critical thing to have due diligence done before a company such as SAA could say, go ahead and conclude an agreement with a particular entity?
It is, Chair, it is a critical thing because you need to know the company that is gonna be bringing money to
Yes.
the company. It is critical.
Otherwise, you would be putting SAA at great risk.
Yes, Chair, hence as well, to emphasize on that, hence Secrest on the same extract was declined. It was declined based on one of the reasons was the due diligence.
And of course, Ms. Hofmeyer mentioned earlier to you that it was strange that one of the reasons why the board rejected Secrest was that due diligence had not been done. But when it came to FDC, they approved FDC despite the fact that due diligence had not been done in regard to FDC either.
Yes, Chair.
And would you have been alive to all of these things at the time of that meeting?
Not with due diligence.
Yes.
For me, Chair, in my capacity, I would have advised the board. I didn't, but I should have advised the board, at least to know the quantum, to know the potential funder and the tenure and all that. I don't think at the time that I was attending that meeting, I would have been alive to say due diligence.
Would it be correct to say that people who are familiar with businesses and so on, and certainly chartered accountants should, when told the board of the SAA approved that an agreement be concluded with FDC involving billions of rand without due diligence being made, would it be correct to say a chartered accountant would say, how could they do that? That would be the reaction. Would that be correct to say that's what one would expect from a chartered accountant?
Not really,
Not really?
Chair, no. That's a
It's
legal
not as bad
space.
as that.
No, not Chair.
It's something that can be entertained.
Not entertained, but if, for example, one would hear that perhaps the board has approved and there was no quantum, there was no interest rate, then you would say in a chartered accountant, why is that? But a due diligence is more in the legal space, so to speak.
But the entity with whom the SAA board would be saying, go ahead and conclude an agreement, could well be proved to be completely deficient or in terms of that. It's not the type of entity that can provide what you are looking for, isn't it?
Agreed, Chair, hence.
And you discover that if you do due diligence, isn't it?
Yes, Chair, hence on my email on the 11th of December, I was mandating the legal department to do the due diligence.
Yes. So your idea was that you were going to do it nevertheless. You were going
Yes,
to
Chair.
go for due diligence.
Yes, Chair.
Even though you accept that it's something that probably should have been done before and that the board maybe should have been advised that wait until there is due diligence.
Yes, Chair.
Okay, thank you.
Thank you, Chair. We are at 1 o'clock. I have
Yes.
one or two follow-up questions on this aspect.
Yes, maybe just take care to ask those.
Indeed, Chair. I've
yeah.
also been told that there's been a delay on the lunch, and that is only
Yes.
available at 1:30. I don't know if that should be taken into account in the decision about when we break, but I was asked to make that known. My sense is if we take the hour and it's only available midway, that should still be fine. But
Well, if we take the hour and that still should be fine, let's take the hour. So, but I think you can ask the two questions.
Indeed.
Yeah.
Thank you, Chair. Ms. Nhantsi, I'd just like to get clear on your understanding of your responsibilities in that meeting on the 3rd of December. You were the interim, albeit Chief Financial Officer of SAA, correct?
Correct.
So you were there to look after the financial best interests of SAA.
Correct.
Correct. You've indicated to the Chair a list of information that should have been before the board, before it decided to mandate you and the acting CEO to conclude this transaction, correct?
Correct, Chair.
Amongst them, I recall you saying there should have been an actual indication of how much was going to be funded, correct?
Correct.
That was not in the letter.
No, it was not in the
And that is
letter,
all that served before the board on that day, correct?
Correct, Chair.
There should have been a term to the loan financing, correct?
Correct.
There also, Ms. Nhantsi, I want to suggest you should have been a clear indication of the rate, should there not? The rate, because you can't assess whether this is going to be in the financial interests of SAA unless you know what the rate is, correct?
Correct.
So, Ms. Nhantsi, I'd like to ask you why you didn't raise any of that with the board on that day, given that it was your responsibility to look after the financial interests.
Yes, Chair, as I've agreed that I didn't raise this and I was supposed to have raised them, hence I followed the process of getting this information, which we did get it on the 24th of December. And if there was any challenge on this, for an example, if the term sheet came back with less than the 15 billion, because on the day the board assumed that SAA FDC will give us either 14 or 15 billion. I take the responsibility that I should have highlighted this, and I didn't, Chair.
Thank you. Chair, those are the questions.
Okay, we'll take the lunch adjournment and we'll resume at 2. We adjourn.
1 2 1 2 1 2 1 2 1 2 1 2 1 2 1 2 1 2 1 2. Check. I'm sure. How about if she's still here? Where? Do you think so?
these people could actually come to us at around 12:30.
That's fine.
Is it fine?
I don't know, but did they tell you if you don't communicate with them? Maybe you should ask them, you know, so that maybe we should go and collect our food.
That's what I'm thinking. For you guys, especially. I do. I'm just coming down with the flu, but I should be fine.
Go and take your food, no problem. In the car and then take your lunch.
$3 coming to us. That's fine. Give me the pan. Hey, oh, mama. You should at least know them.